You gotta admit their music is better than court TV. They're not back yet. Their music is so much better than court TV. I wish court TV had this music. I hope I don't get in trouble for playing it, though. Hey, everybody, my name's Debbie. Welcome back to Closing Arguments. We are doing the Imposter home invasion trial. Hey, Carla. Hey, Judy. Yes, verdicts will be very interesting. We never got to the end of the Hernandez trial. When I was watching it on Legal Bites channel, we never got to the end. But we had the same thing with the two juries, and the one would go out and not watch parts, and the other one would go out and not watch parts. It was back and forth, very similar to how they're doing this trial. So we never got to the end to see about, it was a hung jury. I guess both juries were hung in that one. So I don't know how they do it when it comes to verdict. I guess they each come in separately. I don't think we're going to have a hung jury this time, though. I think this is going to be quick and easy. How many trials lately have we done where there hasn't been a defense? It seems like it's been a lot of them. Are you kidding me? They just showed the courtroom. And then they went back to the wait screen. Yeah, I don't understand the not putting on a defense. Like, I mean, I know they don't have to because they don't have the burden of proof. So they don't have to put on a defense. Like, I get that. But it just seems like if I was on a jury, because we're kind of like the jury, right? Doesn't that make them feel more guilty? I know you're not. I got the hiccups. Crap. Maybe it was just one hiccup. I know you're not supposed to take that into consideration that they don't put on a defense because they don't have to prove anything, but to me that always makes it feel like, well, they don't even have a defense. They couldn't even say anything in their defense. And yeah, I know legally that doesn't matter, but they just always seem more guilty. Not more guilty, but like, that helps me make my decision easier that they didn't put on a defense. And I know if some lawyer were to watch this, they'd be going, "That's wrong, Debbie. You're wrong." And I know I'm wrong. But as a non-lawyer and someone who is likely to maybe sit on a jury one day, actually I'm not. I'm exempt because of my chronic illnesses. But just saying, as a juror, that would make me be more likely to convict. Unless it was crystal clear that they didn't do it. Usually, though, if it's crystal clear that they didn't do it, then the lawyer puts on a defense because it's crystal clear they didn't do it. And if they were smart, but we know they're not, if they were smart, when they got there the night before and they were like, "Nope, it's too late. You're going to have to come back tomorrow," they would have went, "Oops, these people are smart. This isn't a good idea," and not come back tomorrow. But what does Biggin always say? They don't catch the smart ones. I wonder why they didn't charge his wife with something. At the very least, they should have given her immunity and let her testify against him. I wonder why they didn't do that. I screwed up my nails, y'all. Been trying to fix them for 2 days. Oh, looks like Brian Walsh is trying to change venue. I don't know if that'll help. The police that investigated his case was corrupt. Only I think Brian Walsh did it. What a mess. Why can't I polish nails? I need to get some of that liquid latex stuff that you paint around your nails to keep from getting the polish on your fingers. I shouldn't have taken off my acrylic nails. I couldn't get the... It's weird. Sometimes I can get acrylic nails on myself and they'll be so pretty. And then when I take them off and then try to get another set on, I can't do it. They're just ugly. So now I thought, okay, so I'll put gel polish on my real nails. And I got it all over my fingers. There, it's on my nails, but it's on my fingers too. I can't polish nails. I saw a short during the break. I forgot her name. Her alias is New York. She's a reality TV star. And she is as female can be. She's got super, super long acrylic nails to a point with all kinds of diamonds and stuff on them, which I can't stand, because if my nails are like 3D and I feel stuff sticking out from them, it drives me crazy. I like acrylic nails, but not like the ones with all the jewels and stuff all over them. She's got all kinds of jewelry on, full face of makeup. She got those big old, like, spider, butterfly, whatever, eyelashes, long flowing hair. I'm talking girly girl. And she's decided that she is non-binary. Yes, Tiffany. That's it. She's decided that she's non-binary now. And she starts her speech. She so resonates with non-binary. She resonates with them. It's like she can't even speak English. I'm like, okay, you do you, boo, but learn English. You don't resonate, you resonate. She resonates. She says, well, because sometimes I feel more masculine, sometimes I feel more feminine. Everybody does. It's normal. You don't have to put a label on it. One whole summer, I wanted to change my name to Dale because Debbie was too girly. Does that mean I was non-binary for a summer? No. It meant I wanted to change my name to Dale because Debbie was too girly.
All rise. Oakland County Circuit Court is now in session. The Honorable Yes Nicole is presiding.
It's a phase.
Please be seated. Hussein People versus Joshua Zuazo, case number 2024-291-950
She resignates.
FC.
John Petrofess and Andrew McGarrett on behalf of the people.
Good afternoon, Your Honor. Michael McCarthy, P30169, appearing on behalf of the with Joshua Zuazo. Mr. Zuazo is standing next to me and to my left of the table.
All right, sir, tell me your name. Okay, we're ready for closings?
Yes, sir.
And we've gone through instructions and everyone's satisfied with the packet?
Yes, Your Honor. The attorneys thank your staff for helping during the lunchtime break.
Well, they'll appreciate that.
And I
They were running
joined.
around. Yeah, okay.
Yeah, that's right.
Thank you, I appreciate that. So I believe all your jurors are, Mr. Zuazo's jurors are back, so we will bring them in, get right into it, and then instruct them.
And the guy that was showing the video, he was like, I think somebody just wants some attention. So that's probably it. Is she like not in the spotlight anymore or something? Is that why she's all of a sudden trying to resignate? I think a lot of, not all, I'm sure there are some people, I think the people that really have a gender dysphoria thing aren't announcing it.
All right, for the jury, please.
I think all these people that are claiming it to the world want attention. I think anybody that's suffering or struggling are not out there going, look at me.
Please be seated.
And if anybody has it, I feel sorry for you and I will pray for you, but I just...
Good afternoon. All the evidence, testimony, text messages are now before you. The case is going to soon be yours to decide when Judge Bullis gives you the law to take back there. You'll have a written copy to read through. I was watching something just the other day, actually on YouTube, and a guy was talking about perception versus perspective. Looking at things as you go through it through your own perception. You know, you're seeing the events around you, the people around you. But there's also perspective, which is how are those folks looking at you? And that's stepping outside yourself and looking back. And I really thought about that coming into today's closing argument, because my perception doesn't matter. If it was my perception that mattered, I think I don't even need to make a closing argument. But that isn't what matters. What matters is your perception of the case, and that I don't know. So what we're going to talk about are things I think are important when you go forward, but it's impossible, and I'm not going to, and there's no way to do in 20, 30 minutes everything that we've discussed. It's impossible. We all have faith that you took notes. We all have faith that you paid attention. So go back and rely on that when you go forward. Now, we talked from the start about what this case is about and what this case isn't about. And from the start in jury selection, what we said is this is first-degree murder, but it's not first-degree premeditated murder. And we discussed that from the beginning. And Judge Polis will instruct you on what this is, which is first-degree felony murder. And that means, and the people have never said anything different, nor has law enforcement, that this was an intentional killing when they showed up on the doorstep on October 11th of 2024. And the judge will instruct you on the law, which is now before all the attorneys. And I'm not going to go through, there's a stack that Judge Polis will read to you, which there's no point going through it twice. But what you have to focus on regarding first-degree felony murder was that the defendants intended to commit a larceny. And that during that larceny, they caused the death of Mr. Murray by either intending to kill him or intending to do great bodily harm to him or creating a high risk that death or bodily harm could occur. And then the judge is going to instruct you about aiding and abetting, which we also talked about. And it'll say anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. Now, I believe the facts have shown there were 3 people in that basement. Okay, and Mr. Murray is not able to talk about what happened in that basement. But I think the facts have shown throughout this, and I think the text messages tied everything in together even more. That from before, during, and after, these defendants had planned to commit a larceny at Mr. Murray's house. And each of them played different roles and different parts, but each of those parts were going together for that same mission, for lack of a better term. And you'll hear and you've heard that defendant Hernandez started a year before with his contact with Mr. Murray. He had personal contact at his pawn shop in Hamtramck a year before, October of 2023, where he was engaged in making pawns with Mr. Murray's shop. And then you heard, and you have the records, that in February of 2024, Mr. Hernandez appears again. And when he appears again, not only does he take some things out of pawn, but he asks to speak with Mr. Murray face to face. And Mr. Murray came over, shook his hand, looked him in the eye, and talked to the co-defendant Hernandez. And the other interesting part of that, because there are little bits that maybe, what is Hernandez in there looking at? He's in there looking at Rolexes. What does Mr. Murray wear? He wears a Rolex. What does Mr. Murray have on him? He has jewelry.
Oh. I don't know.
After that day, and as things went forward, You've seen the text messages, you've heard the connection between the two co-defendants, and a substantial connection. These are not Facebook friends who never hang out. These are not high school friends that only see each other at reunions once every 5 years. These two have had a close connection, and it continued throughout this time. And I think there's proof of that through witnesses and through the text messages. You heard from Ms. Diaz when she testified how the defendant, Zuazo, was going to be in the wedding in September of 2024. You heard from Ms. Diaz that she knows him by the nickname of Yogi. You heard from Ms. Diaz that she identifies the defendant that morning of October 11th when he's in the Lowe's with co-defendant Hernandez. You've heard as the testimony, the text, everything else is played out. You have lots of videos to show that they put their plan in place to physically start making it happen probably about 20 days before the murder. And you hear that through the text and through their actions. You start seeing the text that you now have today about we need a car between Hernandez and this defendant. And they go back and forth about getting a car. Why do they need a car? Well, they need a car because they want to get away with it, first of all. And they're going to do that by disguising the vehicle that they drive and then disguising themselves. They're going to disguise that vehicle after they steal it, and you've heard testimony from the victim of that theft about his car being left out and it gone, which coincides exactly with the text that you have now. You also saw texts that indicate that you need to disguise it with DT materials. And you saw not just Hernandez walking in on video into that store to order up those signs for the sign of the car, but you saw this defendant text messaging his buddy, whether it's a male or female buddy, I don't know, but the buddy to get DT products to disguise themselves. They go a step further, and that's to get rid of the plate, which was a very distinguished plate on the back of that truck, that Poco plate. And they got a DT plate stolen from a DT vehicle to make it even more unlikely that they're going to get caught if that vehicle's identified, or if it shows up on a flock camera. Like everyone here now knows, is taking pictures of a lot of plates. Well, it would have come back with the DT plate. And that disguise, as you heard, was so effective on October 11th that even Miss Niehaus, as she's walking her dog, and she said, my attention's drawn to that vehicle, first by the sound of it, but then it just seemed to be slow rolling through the neighborhood. And she said, I finally looked up and I saw it was marked as DTE. And I said, oh, it's DT coming through to do something. And she was no longer concerned about the vehicle. Well, that's what these defendants intended. Now, you have the videos, you have the purchases at Home Depot, at Lowe's. They were getting the things that they were planning to use when they were going to get into Mr. and Mrs. Murray's house. They wanted duct tape, they wanted zip ties, they were disguising themselves as workers with different things that they purchased also at those stores. They were ready, but there was one thing that they could not buy at any hardware store for that day. And that was the will to do what was necessary. That will to go into that house and do what was necessary, you can't purchase that at a store. That came from in here. They were ready to go. And on that October 10th, when they drove there, it was this time of year, it is dark. You've got all the text before and after. And as they drive there, 40-minute, 45-minute drive, no one gets out of the vehicle. No one talks themselves out of doing what they're about to do. They're ready. They're planning, and as you saw through the text, Mr. Hernandez wants to buy a house. Mr. Zuazo is talking about needing a big score. And they had this impression that inside that house was going to be their big score. As they get to the house, and as you've heard, they approach the house, Mr. Hernandez in front, posing as DT workers with Mr. Zazo right behind him. And that does not is captured on Ring video. There's the knock on the door, which catches everybody's attention inside. Mrs. Murray said she gets it on her Ring video from her phone, and Sam is already downstairs and heads towards the door. She's upstairs, and she's paying attention. So Sam opens the door. Defendant Hernandez with the co-defendant right behind him. They're trying to talk their way into the house. Mrs. Murray says, it's a little late to be doing a gas check. And then she says, Sam, do you have your gun on you? And she said, I said it loud so it could be heard. Mr. Murray doesn't want to let him in, isn't going to let him in, and doesn't let him in. Mr. Hernandez says, we'll be back tomorrow. So they leave that night, and then they have a 40-minute drive back to where they came from. Did anybody decide not to go forward with this the next day? No, there was a different type of discussion. And there's unanswered questions that we talked about in jury selection. Some of those unanswered questions don't matter, okay? It only matters if it goes to what we need to prove in these elements. One of the unanswered questions is, why didn't they force their way in? Okay, well, they didn't force their way in is what happened. But if you remember the positioning, Sam is downstairs. He is not a small man. He's 6 foot tall. He's 300 pounds. Hernandez is in the doorway, okay? And it's been told that he's armed. Could they have gotten to Sam before he pulled his gun? Could they gotten to Sam before he backed up and pulled his gun? I don't know. But what I do know is if they had come in that house, they could not have gotten to Mrs. Murray upstairs on that balcony before she called 911. There was no way they were getting to her before that call was placed. So they leave to regroup, and they regroup. They don't cancel it. They don't say there's Ring cameras, I'm not going to do it. They don't say the guy is 6 foot and 300 pounds, he may be a problem. No, instead they revise the plan. The plan doesn't get canceled. How do they revise the plan? Well, now they go first thing in the morning to Lowe's to get the 18-inch zip ties. So they're upping what they expect they're going to need to subdue Mr. Murray. The duct tape no longer is enough. They need zip ties, and those are the same length zip ties that the detectives described that is in the bloody scene in the basement. They have the drive back. No one gets out of the car. They both arrive. And as they arrive this time, when they're at the front door, which is captured on the Ring video, they're able to trick Mr. Murray into opening that door. Mr. Murray goes to the door, as you've heard, he lets them in, as you've heard, and Mrs. Murray is there watching this. She says it sounded like Mr. Hernandez was going to go outside, but he didn't. And you also heard that defendant Zuazo starts lingering around where the dryer is, which is a gas dryer. So they start going downstairs, and what's important to note is the little pieces of things, which you have, I'm sure you have. So Sam goes down the stairs first. Who's following Sam? This defendant, not Hernandez. The first one to go downstairs behind Sam is this defendant. The first defendant who's going to encounter Mr. Murray is this defendant. And Hernandez goes down behind him, the door is closed, and you know some of what happens next. We don't know all of what happens next because Mr. Murray isn't here to tell us. What you hear next is defendant Hernandez comes up and he immediately confronts Mrs. Murray, who's right there. She doesn't hear anything for that 10 or 15 minutes. No screams, no shouts, no commotion. But she sees Hernandez, and he starts with, where's the safe, where's the money, where's the jewelry? And obviously, that conversation triggers the realization that these are not DT workers, that this is a problem. And she answers immediately, we don't have a safe, the money's in the purse, there's no real jewelry here, it's upstairs. And you hear at that point in time, defendant Zuazo comes upstairs. And when he comes upstairs, Sam isn't with him. And when Mrs. Murray sees Zuazo, she asks, "Where's my husband?" And she's asking, "Where's my husband?" And he comes up and hears that. Hernandez doesn't say anything in response to that. Zuazo does. And what he chooses to say is, "He's sleeping." And at that point, she sees the blood on this defendant's chest. And she starts screaming. Hernandez immediately punches her on the left side of the face, as you've seen the photos and as you've heard in testimony. And what else does Mrs. Murray say that is important? And as you look back through everything, all that we ever want is for you to use your common sense about what makes sense, what doesn't make sense. And what makes sense is exactly what she says. She says she sees his whole face because the mask is no longer in position. And what makes sense about that, because he's trying to disguise his face with the mask, both on the 10th and on the 11th. But why it's not in place anymore is because he had just been in a struggle with Mr. Murray down in the basement. And that mask had been moved and dislodged during that life and death struggle. And that life and death struggle was just Mr. Murray's life and death. These defendants were never concerned about their life or death. And if you heard, the only blood, there's DNA from the defendants. There's never any blood from the defendants. The only blood that you see, and there's a lot, is from Mr. Murray. Now, she sees his face, she describes him to the police officer, she describes the facial hair, and you heard the officer yesterday testify when he was arrested, he had facial hair. And then you've seen the Lowe's video from that morning where the defendant is there with Mr. Hernandez with facial hair, with the bucket hat that's later found. So now here? No. Where does he head? He heads upstairs to continue the mission, which is to find the jewels or this treasure. Or this treasure that doesn't exist. So he goes upstairs, and you heard that when he goes upstairs, those rooms are ransacked. You saw those rooms are ransacked. The costume jewelry is every place. And you also heard Mrs. Murray testify that Hernandez never went upstairs. Only this defendant went upstairs. And what else is upstairs? The victim's blood on that swipe on the wall. Because there's so much blood that was downstairs, the defendant got the blood on him. As that's going on, Mr. Hernandez is still looking for items, trying to get into the purse, trying to take the car keys, taking the cell phone, taking all these things. And the gun is missing. Gun's never been found. Last time it was seen, it was going downstairs with Mr. Murray. That gun is missing. Mrs. Murray tells you that she's bound up by the duct tape. You saw how Sam is bound up in the basement. He's not just bound up with duct tape, he's bound up with the zip ties that they have just purchased. And then you hear this defendant returns from upstairs, wanting to go. We need to go. But what does he want to do? This defendant. He wants to put Mrs. Murray in the closet. He wants to put her in the closet before they go. And he starts trying to do it with Hernandez, but she's duct taped in a position that she can't be moved into the closet. So as much as they tried to even do more, they weren't able to. So they depart.
So he has to do 2 closings. He does a closing for this jury. then Zuazo's attorney's going to get up and do his closing. Then he's going to do the rebuttal. Then they're going to bring the other jury in with the other defendant and the other lawyer. This is going to get confusing.
And flee. It's not over because they got to try to get away with the little that actual value that they took. The only thing of value that they took that day was Mr. Murray's life. That's the only thing of value that was taken. The rest was junk. What do they got to do? They got to go get that truck down in Detroit, and you saw the text messages where it sounds like it's pre-planned. You hear that they set that truck on fire to burn its contents, burn any DNA that's inside the truck, and then it's time to get out of there. Hernandez gets home. You've heard the testimony that he quickly packs up that Jeep, packs up his wife, packs up her child, and they start headed down south. Now, when they get down south, they don't have much of a drive before law enforcement is quickly on them. Law enforcement finds a lot of objects of value that are later processed. You've heard about all those objects, which include the 13 size shoe, which is Mr. Hernandez, and in fact, the video you can clearly see he's wearing those 11 that are not able to fit Mr. Hernandez's foot. And you also heard today that the defendant's shoe size is 10 and a half. And I don't know about anybody else who buys shoes, but my shoe size range it's a large range between what brand you buy. 10 and a half, 11, 10, they all can fit the same foot, as everyone knows out of their own common sense. So they find the bucket hat that belongs and is seen on the defendant. You also find the jewelry items that were taken by the defendant. All of those things, plus more, are found in that vehicle. Now, at that point in time, the attention of the sheriff's office has quickly been focused on Mr. Hernandez and this defendant also. You heard from Mr. Broad, who calls into the sheriff's office and says, I know that guy. He testified yesterday. I know that guy. I worked with that guy. He identifies him from the video. He identifies the clothing from the video, and he identifies those boots being consistent with the type of boots that are used at their scene. So then you hear more gruesome details today from the medical examiner about the manner that Mr. Murray was killed. Those photos show a lot of light about what happened in that basement. It was a brutal beating, a multiple hit beating, a beating that could certainly have occurred with two people, regardless of their size. But when we talked about the Rolex, it's important when I think about things about how did it physically transpire. He has two strikes to the back of his head from a blunt object, consistent with a gun, consistent with a lot of other objects that could cause that type of injury. Okay, so Sam goes down. They ask for the safe, maybe. He's not giving an answer, maybe. He says, I don't have anything, maybe. But you know that conversation occurs. It occurs upstairs, and they don't like that answer either. So Sam is struck and he's bleeding, but he's not quitting. You heard Mrs. Murray talk about he's a strong man. You've heard he's a big man, and he's not unconscious, because if he's unconscious, how could I say that? I wasn't there. Well, because it doesn't make sense with the rest of the facts in the case. If he's unconscious, you don't have to bind him up like that. You don't have to duct tape him. You don't have to duct tape his mouth. You don't have to zip tie him. This is a struggle at a minimum with Mr. Murray and the two defendants. And what else do you hear? That as much as Mr. Hernandez loves Rolexes. As much as the only thing of financial value in that whole scene that day was probably that Rolex. What happens during this struggle? The struggle occurs to the point where he's duct taped and zip tied where you can't even get to the Rolex. If he was unconscious, if he wasn't there, the first thing that comes off is the Rolex. Maybe they try to get the ring off, but the thing of value is that Rolex. You can't even get to it, but they don't care because they're in a struggle with him. Now, that beating had many injuries to Mr. Murray that you've heard about. And we talked to the medical examiner about the compression to the throat and about if someone's struggling to break that compression, whether it's a knee, a hand, a foot, you know, it would reset your clock. You know, if someone's trying to choke you, you knock it away, it resets the clock, keep doing it. So I believe it's taking two people to try to restrain Mr. Murray. And that fact is borne out by the fact that you have blood on both defendants. There's no version where any defendant left that basement before that violence occurred. Impossible, because you're not getting blood on your boots, you're not getting blood on your Nikes, you're not getting blood on your shirt. Both shirts. Because the t-shirt Mr. Hernandez is tested also has the DNA on the blood. So that battle is going on down there. And, you know, I try to think about it like just normal life, okay? I have a brother, 4 years younger, okay? So growing up as kids, when we would roughhouse, wrestle, things like that, there was a point in time where I could get both of his wrists in one hand. And I could put him down with one hand and hold him in place. And then I had one hand free. That stopped when we were about 12 years old. I could no longer control him with one hand. There was no way one person was controlling Mr. Murray all by themselves. To both tie him up, keep him in a position, do all that, that doesn't seem to me to be reasonable. I think Mr. McCarthy is going to say a few things at this point. Give him your direct, full attention like you have throughout this trial, and then I'll have a few minutes afterwards to address what he says.
Thank you. Mr. McCarthy.
That was a weird ending.
Good afternoon. I want to thank you, first of all, for paying attention during the course of this trial. I talked about that in my opening statement. I think I may have touched on it a little bit while we were conducting the jury selection on Monday, but I did for sure talk about it in opening statement about how important it is to pay attention so that the 12 of you that are ultimately chosen to go back into the jury room and deliberate will have all the information you need in order to actively participate in those discussions. And I'm convinced that all 13 of you here present today, this afternoon, have fulfilled the solemn obligation of your oath. And on behalf of Joshua Zuazo, I thank you for having done so. And now it is, in a short time, going to be your opportunity as well as your obligation to do the one thing that brings us all together here, to discuss the one thing that brought us all together here this entire week, and that is to determine what the facts are. As I said in my opening, I'll repeat again, that a trial is a search for the truth, and you all are the truth finders. You are the people who are going to make a determination based upon the evidence presented during this trial of what that truth actually is. And then ultimately the practical reality of those decisions that you make in coming together and determining the truth is going to be whether you find that there's been evidence presented to the high standard of proof beyond a reasonable doubt to convince you that Mr. Zuazo is guilty of any one of these three crimes with which he is charged and for which he has undergone a trial before yourselves. First-degree felony murder, unlawful imprisonment of Hussein Murray and unlawful imprisonment of Linda Murray. One of the things that impressed me about the evidence that we have heard, and one of the things that I told you in the very beginning of the trial, is that this is about identification. And I understand Mr. Petrofess's argument, and he is attempting to convince you beyond a reasonable doubt that that second person who's there with Carlos Hernandez in the Murray home on the 10th day of October in the evening, and on the following morning, the 11th of October of last year, is Mr. Zuazo. But there's quite a difference between what you're able to perceive in all of the videos that have been shown to you, which, are exhibits, and you are all welcome, as Judge Polis will tell you, any exhibits that you want to see, you're going to be able to see again and go through them. And I encourage you to do that very thing. Especially from that Friday when it's daylight and you can see. And take a good look at who that second person is. And ask yourself, is that really proof beyond a reasonable doubt that it's Joshua Zuazo, or is it somebody else? Because when it comes to identification, besides what you can see just in little clips from those videos, comes from Mrs. Murray and Kelly Broad. He testified yesterday. I believe it was yesterday, it might have been Wednesday. But whichever day it was, he testified during the trial, and he is the person who used to be Mr. Zuazo's supervisor, 2 levels up from him, but some sort of a boss at the St. Mary Cement Company. And I don't know about you, but I had a little difficulty following what he was saying. I know he was here for a reason. First of all, he was subpoenaed, so he's obligated to be here. But he was here to make sure that who he says had threatened him when he fired him got convicted in this crime. He says that he knows it's Mr. Zuazo because in the video he is wearing Wolverine steel-toed boots given to him by St. Mary Cement Company. And he's wearing safety glasses. Prescription, he says, given to Mr. Zuazo by St. Mary Cement Company. So the thing that I ask you to do is scrutinize what he had to say. And the reason I say that is because in the instruction that the judge is going to give to you a second time, she's already given this to you once before the evidence presentation began, is about witnesses and sizing up the witnesses and making a determination about who do you believe. And one of those things that she's going to repeat is words to this effect about, does the witness try to actually answer the questions, or does the witness argue with the lawyer? And I would add this, does the witness ask the question presented? Now, I've been doing this job of representing people in trial and conducting litigation in civil matters as well as criminal matters for 45 years. And so I'm pretty capable of keeping people on point and getting them to answer their question that I put before him. Ask yourself in your memory how many times I had to repeat a question and ask him to answer the question that I put to him. Was he honestly trying to answer the lawyer's questions, or was he arguing with the lawyer? And this is a huge piece of evidence that is presented specifically to fill in some gaps about who that second person is and make it be Joshua Zuazo. I submit to you that Kelly Broad was not honestly trying to answer the questions. He was here with an agenda. He claims that Mr. Zuazo threatened his life, but he never reported that to the police. And he says that he can tell that these are Wolverine boots. The fact is, when I asked him the question, I said, well, all you can see is down at the bottom. The person who's wearing those shoes is wearing long pants. How can you tell all these things? Well, he just knows that that's true. Well, if that's so true, and the people's theory about Mr. Zuazo's presence at that place, the home of the Murrays, then how come there aren't some brown Wolverine steel-toed boots in Mr. Zuazo's house when it is subjected to a thorough search? Why aren't those steel-toed Wolverine boots that Mr. Broad is so certain were present in that video in the Jeep that is racing from Michigan to Texas and is stopped in Louisiana? Those are Timberline boots. And there's no evidence that those are Mr. Zuazo's boots. There's no DNA in those boots that says it is Joshua Zuazo's DNA. There is DNA that says that the blood on top of one of those two boots is Mr. Murray's. No question about that. Who is to say, what evidence is there that is reliable that it's Joshua Zuazo whose feet were in that boot? Where is this shirt that Mr. Broad claims he recognizes as a St. Mary cement shirt or covering, whatever it was, this yellow looking thing that you can see in the video? How do you know that that's from St. Mary? When I told him that there was this, in the video that I watched of him, on his shirt he had a name tag, or the company name is what he said. I couldn't see it very clearly in the video I watched. But he explained, yeah, he says that's St. Mary Cement Company. Says that on this green patch. And then he adds in, well, of course, those can be easily removed. Okay, well, there wasn't one of those on that shirt. And he claims there's this thing on the shirt, though, that says fire repellent. I think was the two words, FP or FR, and so there'd be some kind of safety shirt that the St. Mary people have. He claims he can see that in that video. I encourage you to take a good look at that and see whether that's what you see. Or is what you see a name tag holder, a clip of some sort, something like all of you have for your jury badges, up there on that shirt that the second person was wearing, and not some initials from the St. Mary Cement Company, but just the clip to hold on to the fake DTE Energy tag. Question of fact for you to decide. Then we have the fact that the other person making an identification of Mr. Zuazo is Mrs. Murray. She's a compelling witness. And who among us would ever want to be in her shoes? And this was without question, and she honestly answered this for me when I cross-examined her a couple of days ago. The terrible, traumatic situation, an experience that she's never had before, of course, and is living with to this day, and cannot get it out of her mind, and thinks about it all the time, and certainly has it on the forefront of her mind because she had to come here and give this testimony. And she's here present and has been throughout the time that has passed since the time she gave her testimony. And so one of the other instructions you're going to get is that you cannot let sympathy or bias or any human emotion enter into your decision making. And I ask you to think about the two witnesses from the Oakland County Sheriff's Department who testified yesterday, Deputy Hagelin and Deputy Wigman, about the description of the second individual that Mrs. Murray gave when they conducted interviews with her. Deputy Hagelin was not the first person who saw her. That was Deputy Copeland, who was the first man on the scene. And his interaction with her was rather brief, and he got her out of harm's way, or at least where he hoped it was going to be out of harm's way, so that he could summon more deputies, and he didn't have much interaction with her. Deputy Hagelin took her and put her into a vehicle, a police vehicle, for her own safety and to give her an opportunity to be sitting down and out of all of the activity that was going on in her home and talk to her. And what she told him was that it was a person of average size. Black male, but a person of average size. Didn't give any specifics. That was the same thing that she said to Detective Wigman, who saw her more often. He saw her in the hospital emergency room on the 11th and then of October, and then he said 2 or 3 or 4 other meetings after she was discharged from the hospital that day, in the following days, and those meetings were conducted in the home of her son. But never once did she give a description to say that Zuazo, or the second person rather, who she has now identified as Mr. Zuazo, was 6 foot tall. It was always a black male of average size. Now, she was specific in her description to Detective Wigman about who is, we know, Mr. Hernandez. Very tall and fat, very fat. One of the pieces of evidence that's been admitted during the course of this trial is that when Mr. Hernandez was racing away from Michigan to Texas, where he thought he could hide out until he was stopped by the Cato Parish Sheriff's Department in Louisiana, Shreveport, he got taken into custody, and as is the custom or the protocol for putting a person into custody and incarcerating them, they take some statistics or information regarding that individual, and they have him booked in at 6'6" and 450 pounds. Now, going to the basement of the home of the Murrays on the morning of October the 11th of last year, there was a person weighing 450 pounds who was very capable of squeezing the life out of Hussein Murray by using his foot, using his knee, using his hand, because no matter how you press down, what part of your body, when you're that big, you press down with your knee, your foot, your hand, you're going to have 450 pounds backing you up. And that is a tremendous amount of weight. So when we have this compression, because that's the cause of the death, is this neck compression, not only does Mr. Murray have a fractured jaw, but he has his hyoid bone right up here in the top of his neck. And that is an essential thing you need in order to be able to stay alive. His gets fractured not in one place, but in 2 spots. It's crushed by somebody's sustained effort to do that. Why is that going on? Who is intent about doing that? Well, I was back and forth between himself and his new bride, Mr. Hernandez, talking about getting a house. Hope we have a good score. She's helping him plot this crime that he's committing. And remember, it isn't just a house. Our house. Starting out, this young married couple with this dream of having a house will go out and commit a crime that includes a murder in order to have one. But also, not just any house. Look at those text messages that were admitted, I think, as exhibit number 22, but they're all in there. That house was a nice yard. I don't know why the plotter, the planner, who's up to her eyeballs in this thing, Amanda Diaz Hernandez, the new bride, is not sitting over here at the defense table. But that's not my decision to make. But if anybody is involved in a conspiracy to commit this robbery, this stealing of property from a person who they know to be, they being Hernandez and his wife to be a man of property because he owns a jewelry store and he owns a pawn shop in Hamtramck. And then, you know, he's out there scoping out the house, and you can all see, as bad as the pictures are, given the circumstances under which they were taken, the home, the Murray home, on the 10th day of October was a beautiful place where the upstairs wasn't ransacked. And you can tell they had very nice furnishings and everything was properly appointed. And it was a big house with not one but two stairways. So they've got this man targeted. And you heard Mr. Petrofessa say that Hernandez was over in that pawn shop asking to talk to and meet Mr. Murray. Why is he doing all that? You got any evidence presented to you about Joshua Zuazo pawning stuff at this place, going in asking to talk to her? No. And who's the man in the forefront all the time? It's Hernandez. He's the guy right up there to the front door. He's the guy with the clipboard. And when the police come and they do the search at that house in Lincoln Park that mother, Danielle Diaz, who had the bad leg, was here yesterday with a giant chip on her shoulder, a little difficult to talk to also. When they come and they do that search, among other things, they find the DT Energy cutouts designed by, apparently, one of the two of them, or maybe both of them, worked on it together. A kind of a joint project of the young married couple so they can have their dream house. And that's not in Mr. Zuazo's house. It got searched thoroughly. You don't see one piece of evidence in this trial that came from Mr. Zuazo's house. But there's a lot that came from Hernandez's house. How about that white shirt in the back seat of the Jeep, or the back of the Jeep, that's got Mr. Murray's blood on it? Now, you know, I made a point, and I'm not trying to make fun of somebody because they're overweight or big. I mean, this is only because it's an essential fact in this case. It says 6X, and his DNA, Hernandez, is in the collar, you know, of the shirt. And if it's his shirt, then that just makes perfectly good sense. But the blood, that is Mr. Murray's. There are no clothing items. There is no evidence that connects Mr. Zuazo to Mr. Murray's blood, period. There are shoes, size 13, in the back seat, or in the back of that Jeep, that are taken into custody by the Cato Parish Sheriff's Department and then handed over to the Oakland County, Michigan Sheriff's Office. And those are analyzed. We had the testimony from the DNA witness here, I believe it was yesterday, Ms. Ramirez, and it's you know, up in the octillions, for one in so many octillion, that it's Mr. Murray's blood on Mr. Hernandez's shoe. There's the black glove. There's black gloves seen by Mr. Hernandez, or on Mr. Hernandez during the crime. And what do we have in the back seat? His DNA inside those black gloves. No question he was there. No question that this horrible crime was committed and that he is responsible for it. And this whole idea of all this was supposed to be as a robbery. Well, you know, I can't tell you what's in somebody's mind any more than Mr. Petrofessa can on the day that the criminal thing occurred. I don't know what Mr. Hernandez is planning on doing, but I do know that, well, there's no doubt, no reasonable doubt, that he is responsible for all of those things that happened. There is no such evidence beyond a reasonable doubt that it's Mr. Zuazo. Let's look at one other video. It's at the Lowe's. It's at 9:30 in the morning, and it's down in Allen Park, I believe. And that video shows Mr. Hernandez walking around inside the store, and then he's buying items, and then he pays for those items. There's another person with him. The people allege and argue that it is Mr. Zuazo wearing this bucket hat. And the bucket hat gets found in the back seat of this Jeep. Now, I'm not much of a hat wearer. I have a couple of baseball hats, but that's about it. I understand, though, that there are people that like that type of style of hat, and I guess in sunlight or sunshine, warm days, maybe it's a good thing to have. Keep your face from being burned up or your neck. Well, whatever the reason somebody's wearing it, if it was Mr. Zuazo, you would think that there would be some DNA on that hat, on the inside of that hat, for this person who's wearing it, if in fact that's who it was. We don't have that in evidence. We don't know whose hat that was. We don't know who was wearing it. We don't even know, really, whether the person who was wearing that hat left that hat in the back of the Jeep. But we have one other thing, and that is a number of items taken from the Murray home, stolen. Any of those at Mr. Zuazo's house? Any item from the robbery, the larceny, rather, that took place as the predicate felony to charge first-degree felony murder in the hands of or anywhere near where Mr. Zuazo was? No. Let's talk a little bit about leaving town. This Mrs. Diaz, the mother, Danielle, testifying yesterday, she doesn't really know when they left. They were going to leave. They were always going to be leaving. But, all of a sudden they were going to be leaving maybe that day. She was asleep because she works these long hours. So she doesn't want to give you too much information. She surely wasn't, I would say, a cooperative witness. I wouldn't tell you that she lied absolutely, but I wouldn't put a lot of faith in what she had to say. But I got thinking about the newlyweds, and what I didn't hear about from either one of them, even though they have this desire to have their own house, is that either one of them had a job. We got some text messages about being behind on the rent by 5 days on the house down in Texas, or the apartment, or whatever kind of a residence it is. And then, the response is, yeah, well, we spent all that money in PR, which I imagine is Puerto Rico, but I don't really know. Probably the honeymoon. And so, no job, no means of getting the dream house or even putting food on the table. What's going on here with Mr. Zuazo? Where is he when he gets arrested? Monday morning, October the 14th, or maybe it's the afternoon, but sometime on that day when the fugitive apprehension team comes to the job site where he's working. He didn't leave town. He didn't go anywhere. He's here, easy to find. The only reason they find him is because of this Kelly Broad coming in with his chip on his shoulder to identify him and say, well, I think this is the guy. Getting even for whatever it was that he's not happy about. But Mr. Zuazo's not down in Cato Parish, Louisiana, heading to Texas. He's not getting on a plane to fly to Europe or something like that. He didn't go anywhere. Well, now why would he just be sticking around while Hernandez has gotten out before the day is over? He's on the road heading home because he doesn't have a guilty conscience. He didn't do anything. He's got nothing to run from. Let's go back to Lowe's. 9:30 in the morning. You have this video, maybe it's Mr. Zuazo in there, that's going to be for you to decide. Let's say for argument's sake that it was him. That doesn't prove that he went anywhere beyond that place where that store, where Mr. Hernandez made the purchases or paid for whatever it was he got. And what do you see with Zuazo? What's he got? Bottle of pop. Look at those videos. Or a bottle of something. I can't tell you it's pop. Look at those two receipts, the one from Lowe's, the one from Home Depot. There's some sort of drink in both of them. There isn't any question that these men know each other. The question is, were they there together that day at the Murray house? Are they both responsible? And certainly Hernandez was. But is Mr. Zuazo with them then? Not at 9:30. There's no crime committed at 9:30 in the morning down in Allen Park. Is he responsible for the wrongdoing in which Mr. Hernandez was engaged at 11:30 to noon later that same day, the 14th day of October? That's the question. That is the key question of fact in this case. Now, in the instructions you're going to receive, you've heard this once before, and you'll hear it one more time by Judge Polis when she gives her final instructions. But it's the instruction about presumption of innocence, burden of proof, and reasonable doubt. And I ask you to keep this in mind because she's going to say this to you. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. And then it goes on to say a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful consideration and careful and considered examination of the facts and circumstances of the case. This is essential to making a determination of the truth here. You have to be firmly convinced that Mr. Zuazo is guilty of any one of these three crimes, because the same standard applies to each crime charge, and you have to consider each crime charge individually. But no matter which one you're deliberating upon at a given time during those deliberations or discussing, think about that. You have to be firmly convinced that he's guilty beyond a reasonable doubt. And I told you in the beginning that this would be the key to the defense presented. They have the right guy. And when she instructs you on this particular point of law, Judge Polis is going to say, among other things, in deciding how an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. So, in the case of Mrs. Murray, this has particular relevance because her state of mind at the time would be one of terror. Whose state of mind wouldn't be that way? She had interactions with the police. They were back to see her multiple times. She's the only eyewitness. So she's a very important person, and I think it would be very difficult if I was a detective investigating this case to have to bringing up this wound with Mrs. Murray so soon after it happened and asking for more details, but they have nowhere else to go to get this information. And in the back and forth, she comes to have an understanding of who it is that the suspect is. And so she's able, without question, when she testified here very clearly, she's able to use names. She's She knows who the defendants are, without question. And she can certainly identify Hernandez. But I submit to you that she has adopted an understanding that Mr. Zuazo, because he is the defendant, is actually the person who was there in her house. She's testifying honestly. She's simply mistaken. And I think that that is a common enough thing that can happen to a person who's a victim of a crime. And even if she wasn't a victim herself, although she was or is, for the unlawful imprisonment perpetrated by Hernandez, who tied her up with duct tape, she's got all that trauma to deal with. So that could have an effect on her ability to recount the events completely accurately and to be able to identify Mr. Zuazo. Now, there's something about blood on the sleeve of the person, the second person. But we don't have that in evidence. So we don't know whatever happened to that sleeve, the shirt it was on. It's just not before you. It's something that was seen. And there's another thing, there's some blood on a wall upstairs, a blood mark. I didn't hear any evidence about any DNA being taken from that stain on the wall. So while one might, under circumstantial evidence, because you'll get an instruction on that as well, be able to say, well, you know, this is a blood mark up there, and there's this horrible thing that happened, and maybe that blood is Mr. Murray's blood. And maybe it is, and maybe something happened where some accident occurred and there was some blood that ended up on a wall that didn't get cleaned up immediately. I mean, I know there's been things in my own home that have gotten messed up that didn't get cleaned up immediately. Sometimes you don't notice something, and it's quite another when the police investigators, I think that Ms. Myra testified to like 15 people being there on the afternoon and into the evening of the 14th of October last year. They're going to see everything. They're looking everywhere. But how long that was there, we don't have any testimony to that. We certainly didn't hear Ms. Murray say, well, you know what, I never had anything like that there before. It wasn't there that day. That wasn't the testimony. At least it wasn't touched upon. Reasonable doubt? Whoever went upstairs did ransack the place. It's all terrible. It's a horrible tragedy. I, even though I'm an advocate for Mr. Zuazo, because I'm not a juror, can at least allow myself to have compassion or sympathy for Mrs. Murray. You all can't do that while you're deliberating and thinking about what the facts are. You have to use what I told you about in opening statement, or my opening statement, is that cold-eyed calculation to come to a determination of what the truth is. I know that's what you're going to do when you deliberate. I appreciate all the attention that you've paid to me here this afternoon, all the time, that you have, all the attention you paid during the course of what is now the fourth day of our trial, all 4 days. I've done everything that I can do for Joshua Zuazo. I'm going to sit down in a minute. And Mr. Petrofessa is going to get up and attempt to poke holes in what I've just told you here this afternoon, because that's the way the system works. He gets to talk twice and I only get to talk once because he has the burden of proof. And so he gets the opportunity to give a rebuttal argument. And that's the way the rules work, and that's perfectly fine. I'm confident in that burden of proof business, and I am very confident in proof beyond a reasonable doubt that you will find that Mr. Zuazo, that hasn't been proved against him, and that he would be found not guilty. But when Mr. Petrofessa makes his points, I ask you to keep in mind those things that you anticipate after I've talked so long that I would have said, given an opportunity to get up again, which I won't have. And as I told you a moment ago, I've done everything that I can do for Joshua Zuazo. And now I leave him with you and in your capable hands. Thank you.
That was the most intelligent
Thank you, Your Honor.
You're welcome.
argument he's made through the entire trial. He was actually competent.
My goal now is to stop talking about 60 seconds before everyone stops listening. It's very intense. Closing arguments have been long and also intense. So let me start by saying, in a response that wasn't how I was planning to say it. Mr. McCarthy, I've known for a long time. He's an excellent attorney. He's an ethical attorney. He would never intentionally mislead you from something that has occurred during the trial. A lot of stuff happened yesterday. A lot of DNA evidence came in, and I believe Mr. McCarthy misspoke just now in his closing. Mr. McCarthy said that blood swipe upstairs was never DNA tested. It was DNA tested. That was in the lab test number 5 that we had testimony about yesterday. It's exhibit number 8E. It's the upstairs wall swipe, and it comes back to the victim, Sam. You have the report, and that's an and I don't believe, and the same thing, that wasn't correct. That was tested. Now, a couple other things that he mentioned was about missing evidence. Well, you know what the defendants did as soon as they left the residence that day. That was to go destroy evidence. So I don't know what was burnt up in the vehicle, but they attempted to burn up the vehicle, destroy DNA evidence. You know, a lot of things weren't recovered that were taken. Cell phones weren't recovered. The pistol wasn't recovered. The cash wasn't recovered. And Mr. Hernandez left town immediately because he had someplace else to go. This defendant was still here, but he had several days knowing what was going on, knowing what was in the media to get rid of any evidence that he may still have had, so it wouldn't be as residents with the sheriff's office showed up. So it's not surprising that there wasn't any additional evidence that was found there at the house. Now, there's certain things that, when we talk about Mrs. Murray, when we talk about the witnesses, that it's beyond common sense, it's beyond reason when you're looking at things. It's impossible. Just certain things about this identification of this defendant would be impossible to have happen if it wasn't accurate. I don't have to prove impossibility, beyond impossibility, but it's actually impossible in my estimation regarding Mrs. Murray's identification. She says, square away, I saw his face when the mask dropped. She says that. She identifies the defendant. She identifies him under oath back in December of last year, says, I recognize him from the house. Okay? Now, what's impossible about that identification if it's a misidentification? Well, what's impossible about that misidentification when she says it a year ago, when she says it under oath? What's impossible for Mrs. Murray to know? It's impossible for Mrs. Murray to know that the defendant's DNA is going to be found in the basement of her house. That's impossible. And if you notice, the one thing we didn't hear, although we had opportunity to discuss anything, was anything about the defendant's DNA on that duct tape. Two sets of duct tape in the basement of that house. That wasn't discussed. That's identification. What else is impossible? Well, when Mrs. Murray is making that identification, she doesn't know if there's a connection between her and she doesn't know that there's all the text messages. The investigation went back and it wasn't that. What if the investigation went back and it was somebody else's DNA in the basement? To discredit that identification? No. Everything that goes forward says this is the right guy. And what else you have that can't be created? Mrs. Murray doesn't know that Ms. Diaz is going to know the defendant. that she's gonna know the defendant and his connection with Hernandez. It's impossible for that connection to have been known by Mrs. Murray when she made her identification. It's impossible. And what else is impossible is that Mr. Broad, when he testifies, he says, yes, I also know him by Yogi. Impossible for him to know that Mrs. Diaz, who's also gonna identify him, knows him as Yogi. It's gonna be impossible that he knows the connection with Hernandez. Hernandez is the obvious guy on the video. But he doesn't know that. He never has talked about Hernandez. But he knows the defendant. It's the rest of the investigation that brings everything together, that all these are connected to the defendant. It was also said at one point that on October 11th at 9:30, he hadn't done anything wrong. You've seen the planning that had gone through this case way before the 11th. You had seen the planning that this defendant did to get the DT items, to get the helmet, to get everything else that was needed to be impersonating DT officers to get into that house. So we're supposed to believe that somehow he all preparation work, that somehow he's identified by all these witnesses, but somehow there was somebody else who was there with Hernandez on the night of the 10th, and then suddenly that person disappears and he's the one who goes with him to Lowe's, and then suddenly he disappears again. That's not reasonable, and that's not what the facts are. I'm going to end it here, but I believe when you go back, you're going to conclude this is the other person who was there, as the testimony, the DNA has said, and that the defendant is guilty as charged on all counts. Thank you.
Okay, thank you. Members of the jury, the evidence and arguments in this case are finished and going to now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You should take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime
Done
is
with old
presumed to
man.
be
Now we
innocent.
got the next
You must start with
jury.
the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide this case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only sworn testimony of witnesses, exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'm going to describe some of the things that are not evidence. The fact that a defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law, and I tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case only from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that was let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge that you have about a place, person, or an event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think that their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice that you may have based on a witness's disability, race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you might need to test what might be an automatic or instinctive judgments and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How did the witness look and act while they were testifying? Does that witness seem to be making an honest effort to tell the truth, or did the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about what testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide this case. And if so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things and told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 11, 2024 in Oakland County, Michigan. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. But facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person coming come in from outside wearing a raincoat covered with small drops of water, that's circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on statements of facts, those are called stipulated facts, and you may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. And you've heard testimony from witnesses who have given you their opinion as experts. Experts are allowed to give opinions in court about matters that they are experts on. However, you don't have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts that they give for their opinion and whether those facts are true. You should only think about the expert's qualifications and whether their opinion makes sense when you think about all the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. As to count one, the defendant is charged with the crime of first-degree felony murder. To prove this charge, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to cause great bodily harm to Hussein Murray, or he knowingly created a very high risk of death, or great bodily harm, knowing that death or harm or such harm would be the likely result of his actions. Third, that when the defendant did the act that caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, at the time the property was taken, the defendant intended to permanently deprive the owner of that property. The defendant must have been either committing or helping someone else commit the crime of larceny. To help means to perform acts or give encouragement before or during the commission of the crime that aids or assists in its commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or someone who aided and abetted caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant or someone that he aided and abetted had one of the three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death or great bodily harm, knowing that such death or such harm would be the likely result of his actions. Third, that the killing was not justified, excused, or done under any other circumstances that reduced it to a lesser crime. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. As to count 2, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly restrained Hussein Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. As to count 3, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly restrained Linda Murray. Restrain means to forcibly restrict a person's movement or to forcibly confine the person so as to interfere with that person's liberty without the person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony, or to facilitate flight after commission of another felony. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that this crime was committed and the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good of a chance the witness had to see the offender at the time. How long was the witness watching? Whether the witness had seen or known the offender before. How far away what the witness was. Whether the area was well lighted and whether the witness's state of, and what was the witness's state of mind at the time. Also think about circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during that identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with the identification of the defendant during this trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant as long as you believe the testimony and if you find that it proves beyond a reasonable doubt the defendant was the person who committed the crime. In this case, the defendant is charged with committing first-degree felony murder and 2 counts of unlawful imprisonment or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or the crime alleged was a natural and probable consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime and whether his help, advice, or encouragement actually did help, advise, or encourage the crime. Even if the defendant knew that the alleged crime was planned or being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. When you go to the jury room, you're going to be provided a copy of these written final instructions. You should first choose a foreperson. The fourth person should see to it that your discussions are carried on in a business-like way and that everyone has had a fair chance to be heard. During your deliberations, please turn off cell phones or other communication until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk with each other and make reasonable effort to reach an agreement. Express your opinions and the reasons for that, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you first consider the principal offense. If you agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe the defendant is not guilty of the principal offense, or if you can't agree on that offense, you then may consider the lesser offense. It's up to you to decide how long you consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense, if you want to. If you have questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you're going to submit them in writing in a sealed envelope to the court clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court clerk. It's not proper for you to talk to me, the lawyers, court officers, or anyone else involved in this case. And as you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and these full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. As I said, you are going to get a copy of these written instructions that you just heard, and you should think about all my instructions together as the law you are to follow. Is there any objection to just giving the jurors exhibits if they ask for them without reconvening?
No, Judge.
There's none by the defense.
Okay, thank you. All right, so the defendant is charged with 3 counts. That is, with the crimes of first-degree felony murder and 2 counts of unlawful imprisonment. These are all separate crimes, and the prosecutors are charging the defendant committed all of them. You must consider each crime separately in light of all the evidence in this case. You may find the defendant guilty of each or any one or any combination of these crimes, guilty of a lesser serious crime or not guilty. A verdict form is prepared and will be sent back with you. All right, so just some logistical things I want to talk to you about. So from this point on, when you go back, I do not manage your time back there in the jury room. If you want to take a break outside of your jury room, you're going to write a note. I would first go back and pick a 4-person, choose a 4-person, and then moving forward, a note should be written to court staff to let me know when you're going to take a break. So if you're going to take a break amongst yourself in your jury room, I don't need to know that. But if you want to leave your actual jury room and go get a cup of coffee, what have you, take a walk, whatever it is, you have to let us know. And you are going to write that in a note. You're not going to be able to immediately leave. When you write that note, the note is then brought to my office. I read it, and then I will say whether or not it's an acceptable time to take a break. So don't leave your jury room unless you're told you can. But I tell you all of that to say you could decide that you need a break right away, or you can decide you need a break 1 hour, all right? So I'm not going to manage your time moving forward. You're going to get a buzzer if you haven't already gotten one when you're back there. And anytime you want to have any conversations with the court or ask for a break or have any questions regarding any evidence, etc., you're going to use that buzzer. A member of court staff will come over to your jury deliberation room. They're going to knock really loud and say, stop deliberating. So you are to stop deliberating because they do not want to be a part of that deliberation. You come in, you hand them a manila envelope that will have your note. That note is then brought to me. They can't answer any questions for you, okay? If the note now is anything outside of I need a break or I want the evidence, which the lawyers just said they were okay with sending back to you without reconvening, anything else that is written on that piece of paper requires all of the parties to come back into court and it is read into the record and the lawyers offer their opinions as to how it should be answered You're then brought back in the courtroom and that answer is given to you. Why do I tell you that? Because we obviously have two juries, and sometimes even when we have one, that answer is not immediately able to be given. Do not feel like the court is not answering your question. I didn't go home, I didn't fall asleep. I promise you, I'm getting you that answer and I'm working to get you back here to get it. Another question that I typically get from jurors is, I didn't see this in the evidence, but may recall from the testimony or maybe in your notes that someone referred to a document, one of the lawyers referred to a document, or maybe lifted something up. If that is not in evidence, it is not coming back to you. And I'm telling you that because it's not because we forgot to give it to you. If you still have a question about that evidence, go ahead and ask for it. But don't be concerned that something in that evidence package isn't sent back to you. Also, there's digital evidence in this case. I am not going to provide you immediately an electronic device for you to be able to view that. If you want an electronic device to view the digital evidence, you are going to have to ask for that, either in that same note or in a separate note, okay? All right, so I think I've answered most questions, and obviously at this point we have 13 of you. So we are going to draw lots to determine which one of you will be excused as an alternate. Generally speaking, an alternate is not typically called back, in all honesty. But in a case like this, I'm unsure how long the deliberations are going to go on for, and it could be very likely that you could come back. So if you're an alternate, all of those restrictions that I had given to you early on are still going to apply, even if you're allowed to leave for the rest of the day. Know that the moment I get a verdict from your jury peers, a member of court staff will call you immediately to let you know a verdict has been reached. And if you'd like to know what that verdict is, they'll provide that information to you. And it's my understanding that we already have everybody's phone number. So if you're excused, you're going to be able to leave at this point, or you may stay. It is completely up to you. The restriction regarding talking to media, if you're an alternate, remains until you hear that you are not required to come back. All right, we're going to draw lots and see which one of you will be
Judge,
excused.
you can approach first before you do that, for 5 seconds.
So it's basically going to be titled People of the State of Michigan versus Joshua Zuazo. The verdict form is going to say you may return only one verdict on each count, mark only one box at each count on the sheet. Count 1 is going to list first-degree felony murder. There's a box to check not guilty. There's a box to check guilty as charged of first-degree felony murder. And then there's a third box under that count that says guilty of the lesser offense of second-degree murder. Count 2 says unlawful imprisonment. There's a box that says not guilty. And then there's a box right under it that says guilty as charged of unlawful imprisonment. Count 3 is unlawful imprisonment. There's a box that says not guilty, and the box right under it says guilty as charged under unlawful imprisonment. When you fill this form out, that is what you want to leave with you in your jury room. Your foreperson signs it and dates it. When you let me know that you got a verdict, you just write a note to say, we have reached a verdict. And then you are brought out here with that folder, and that's how we take your verdict. Okay? Satisfied?
Yes,
Yes, sir.
Okay, all right, let's pick a lot to see who is going to be excused.
Juror 14.
All right, so that is New Jersey 14. You know what, any of you, when I excuse everyone, then we'll just have somebody take you down the hall. At this point, I am going to go ahead and swear in my clerks. Please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise except by order of this court, or to ask them if they have agreed upon their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I will.
All right, thank you. All right, ladies and gentlemen.
All rise for the jury, please.
Any objection to the form and manner of the reading of the verdict, of the jury instructions?
No, Your Honor.
No, Your Honor.
Okay, all right, so then we will get that door closed. And, Mr. Zuazo can go down, and if I hear from the jury, I will, let you know, Mr. McCarthy,
I'll
and we'll
be
bring him right
nearby.
up. Yes,
I'll
you'll be
leave my
nearby, okay,
number
great.
there.
And,
Yeah.
do you want about 20 minutes?
No.
You wanna get right into it?
Yes.
All right, so then let's get Mr. Zuazo down, we'll get Mr. Hernandez up.
Thank you, Judge. And just so your clerks know,
Good, let's do this thing.
we
You
can
know
fix
what,
it.
I didn't tell them about
Yeah.
and they can't just open
We'll-
those packages.
we'll do
Why don't we,
We'll deal with it as soon as.
why don't we get through your
Yes.
closing, and then when I get the evidence, we are gonna reconvene for that, so then I can explain to them that they can't just, if they
What?
do go through the packages, they are gonna need gloves and also.
It's, yeah, the photographs we should be able to do. I think we should have everything ready. I don't think you need to bring them back to discuss that until they have a question. But we should get that for you. Once the attorneys are talking.
No, my concern is, are you sending back the physical items of
Not
evidence
unless they
that?
ask for it, no.
We'll see, but I didn't clarify that for them, so I will bring them back to clarify that.
Okay.
Okay, all right, I'll be right back.
All rise.
You've got two juries and one set of evidence. How does that work? And they're going to be in two separate rooms, right? Is the evidence going to get passed back and forth between two rooms? What are they going to do? Send out a note like, I want to look at that evidence now? Can we switch evidence? I hate two jury trials. They should always sever, in my opinion. Any day now. Is he staying in the courtroom to listen to the other closing arguments? Oh, guess not. That judge's accent is driving me crazy, y'all. I know she can't help it, and I feel bad that it bothers me. But it still bothers me. She needs a spa day. You can see the tension. she holds in her shoulders just by, like, when she walks by. Who's the dude all dressed up fancy in the gray t-shirt? And the jeans. Oh, not even jeans, shorts. And deck shoes. I thought he didn't want to break. I thought he wanted to go right back into closings. Why are we breaking?
this game keeps popping up on my phone and keeps saying play now, and it's a Disney game, and then I want to play it. I go to play it, and it says not available until October 8th. They lie. It's a Disney game. It's a new Disney game. I want to play it now. Oh, we were waiting for him to come back. That's why we're waiting. Guys, it's Friday afternoon. The past 2 weeks have been exhausting. We have done so much in the past 2 weeks. I'm sorry, guys. I'm tired. I'm sorry I'm not more entertaining right now. I'm tired.
Vice. Thank you. You may be seated.
Kelly People versus Carlos, case number 2024-291945 FC.
John Petrofessa, Andrew McGarrow on behalf of the people.
See you.
Paula Michelle Lofton on behalf of the defendant, Carlos Hernandez.
Can I tell me your name?
Carlos Hernandez.
Okay, we're ready for closing then?
Yes, Your Honor.
Okay, we will bring in Mr. Hernandez's jury. You can come right in here. Welcome back. Please be seated. Ladies and gentlemen, I apologize. I see my estimation was significantly off, but we're ready to go. Go ahead, Mr. Petrosa.
Mr. Support? Counsel? Good afternoon. There's been a lot of evidence, a lot of testimony, experts who've testified. It's been a very intense 3 days. I understand that. Ms. Lofton understands that. And as I stand here before you, I'm always thinking about what do I say at the end of the case when I know you've all paid attention. I know you've taken notes. And I actually saw something on TikTok last week that made me think about this, which was a guy was talking about the difference as you go through life between your perception of things, which is how you walk through life and you look from your set of view to what's going on around you. You see your family, friends, work. That's your perception. But there's the perspective. If you step out of yourself to look back at you in that picture, you in the group of everything that's going on around you. And that's really what I think about now, because from my perception, I don't need to make any closing argument at all. I believe you. As the judge will instruct you, the death of Mr. Murray was either because they intended to kill him, or they intended to do great bodily harm, or created a very high risk of death or great bodily harm in that commission of the larceny. And you're also going to hear, which we also discussed during jury selection, anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. And as you know from everything that's been presented, on October 11th, 3 people went down into that basement. Not tell you what Mr. Murray saw because he's not here. I will tell you that what you've seen in this case, especially today with the text messages, I believe it shows very clearly that this was a plan both before, between the defendants, during, and then after. And the plan was to get rich by robbing the Murray's home that day. They had a belief, which was false, that there was a lot of valuable things in that house. And there wasn't. The only thing of value that was taken on October 11th was Mr. Murray's life. That's the only thing of value. The rest of it is almost junk as far as value. A cell phone, some cash, junk. But that's what their intent was. And that intent, as you've heard, started in the process, in the works a year earlier in 2023 in October, almost exactly a year earlier, when this defendant started to have his dealings with the pawn shop of Mr. Murray and Hamtramck. He would go to that pawn shop, he would pawn items, he would get cash, he would have contact with that pawn store, and then you heard in February of 2024, he returned. And when he returned in 2024, as you heard from Hussein, he asked, as he was looking at the Rolexes, and the Rolexes, I think, have a secondary importance when you see what happened and what you saw happen at the scene. He sees the Rolexes, he spends a lot of time, 10 minutes, looking at the Rolex case, and then he asks her to see the owner. And she brings the owner to him. And the owner looks him in the eye, shakes his hand, introduces himself as he's wearing a Rolex, as he has a necklace on, and that's a solid identification of how the first connection between the defendant and the victim occurs. And you heard in that statement that was played yesterday, when he's paddling everything he can to stay above water down in Cato Parish. And he throws out there, because the detectives don't have everything at that point. It's very fast. The investigation happened. It was successful, identifying the defendant very quickly. And part of it is from the obvious. You don't have to have known the defendant for your entire life to see that Ring video and say, oh, that's the defendant. Very distinctive. The focus was on him quickly. But in Cato, if you remember what he starts saying, well, you know, this was set up by some third guy. He starts coming up with this. He was identified, the victim was identified by a third guy. No, it's not a truthful story, and you're trying to get yourself as far away from what happened as possible. In fact, you knew the victim directly. You saw the victim directly. And at that store, as you heard, Mr. Murray's Audi was always parked in the same location outside that store, visible to folks who would come and go, just like it was parked visibly in front of his house. You hear that as time develops, and he's back here in 2024, in September, you start seeing very clearly by into Mr. Murray's home. And they also intend to get away with it. They're not trying to get caught. They plan on getting out of there. And what, as you see through the text, tightly linking it, what are they going to do to get out of there? The first text between the defendant and Zuazo, and also Amanda, has to do with stealing a vehicle. He texts, we need to steal a car. Okay, why is that? Well, because he doesn't want to show up in Rochester Hills in their Audi, in their Jeep, with their plate on that Jeep that can be tracked back. As we all know, the Flock system tracks plates like that these days. I had no idea Lowe's tracks plates like that these days also. So license plates are a very quick way for law enforcement to identify folks. So they're on it. They're planning to steal a vehicle. And then, in fact, as you hear from the owner of that pickup truck, his vehicle was stolen, I think, on September 30th of last year from out in front of the house. So now they have that vehicle, but that vehicle has a very identifiable plate. Poco, it was the company name. Poco is part of the plate. So to disguise it another level, a DT license plate gets stolen to put onto that vehicle. Poco is replaced for an actual DT plate. That's the level of disguise that is going through, and that disguise is to get in the house and to get out of the house without getting caught. Now, you've seen the text as it progresses. The defendant is coming up with ways to make that truck look like a DT vehicle. He is going in person on video to order that DT nameplate for the sides of the truck. As he's doing that, he's sending those samples, his proofs of what it's going to look like to the co-defendant. And as he does that, he's also on video picking it up. The poor guy who owns the sign company was so afraid that he was somehow involved with the homicide, he immediately calls the sheriff's department after it takes place. So then you hear what else they're doing to try to disguise their appearance. They're going to Home Depot, they're going to Lowe's, they're getting other type of work materials that would look like they're DT people to disguise themselves. You see Zuazo is communicating with one of his buddies who actually worked with DT and had DT equipment and helmets to get that as part of their plan. And then they're ordering at Home Depot duct tape. And after they get the duct tape, you'll hear that the plan is in place now. They're basically ready to go. But there's something that they weren't able to prepare for and buy at Home Depot or Lowe's. Something they needed to accomplish that. And that something was the will to do whatever was necessary to get into that house and to commit that larceny. That will to do that, that comes from in here. That you can't buy. So equipped with all the things that they have pre-planned, they head to Rochester Hills on October 10th, late. They have an entire long drive to get to Rochester Hills. They don't turn around, they don't leave, they don't decide not to do it. They show up at 10 o'clock. And when they go to that door, which has Ring cameras, and I think you'll remember in passing, the deputy within seconds of getting there, before he's even been inside, says there's Ring cameras all around this house. They're that visible. They're not secret Ring cameras. So you're on Ring camera. And as they get to this house, who's leading the way to the door? This defendant. He's at the door first. He's the one who's making contact. He's the one who's the knock on the door. And Mrs. Murray's alerted on her phone because everything bounces to the phone from Ring camera. And Mr. Murray is downstairs while she's already upstairs getting ready for bed. And as he goes to the door and answers the door, and there's the defendant with the co-defendant behind him, dressed like DTE, trying to disguise their face with the mask that they're wearing. Said, we're here to check the gas leak, we need to get in the house. And Mrs. Murray, who's hearing this from upstairs, says, isn't it a little late for a gas check? And the defendant continues talking to Mr. Murray. And she yells down, Sam, do you have your gun on you? And she said it loud enough with the intent for the folks at the door to hear it. And we know that her husband did have a gun and that he would carry that gun. So as that's being said, her husband isn't letting him in at 10 o'clock. There's no smell of gas in the house. So, no, I'm not letting you in. And the defendant has a clipboard to make it look like they're there to get permission and consent. It's even part of their text messages about making it look like there's a consent form when you go to the door. More ways to trick the Murrays into letting him in. It wasn't happening on the 10th. The defendant says, we'll be back tomorrow. And he leaves. And that door shuts. And we've talked about before in jury selection unanswered questions. And there's unanswered questions about why did they leave that night on the 10th. And those questions don't have to do with the elements to prove about what happened on the 11th. But, you know, when you're opening that door and you've heard Mr. Murray is not a small person, 6 foot tall, nearly 300 pounds. And then you hear it accompanied by Mrs. Murray saying, do you have your gun on you? So now you have the defendant who's the first one closest to Mr. Murray. So in those moments, was there a calculation that he was not going to be able to get to Mr. Murray before Mr. Murray could back up and pull his weapon? Was there a calculation that if there was going to be a struggle, it was going to take a while? And you also heard that Mrs. Murray was at the top of the stairs. And I don't know what calculation could have happened if they had gone in at that moment, but there was no way they were getting up those stairs to Mrs. Murray on the second floor before she dialed 911. No way. There wasn't any way to accomplish that. So they leave and they drive back, a long drive back. And in that drive back, do they decide, we're not doing this again tomorrow, this is a mistake? Do they decide that we're not gonna go against the Ring cameras, we're not gonna go against Mr. Murray, we're not gonna go against the potential that he's armed? We're not gonna go against the Oakland Sheriff's Department if they're called?
You know, who says if there might be a potential gas leak, we'll go away and come back tomorrow? You could be dead tomorrow.
We're not going to go against the law. Do they decide that this is a bad decision? No. Instead, they're already texting that night between the two of them about the plan for tomorrow. What time am I going to get picked up at? And they also decide that whatever they brought on that first trip on the 10th, it wasn't enough. The plan had changed after seeing Mr. Murray at the door. Now they wanted the extra long zip ties. And those are the extra long zip ties you see, unfortunately, in that gruesome scene in the basement. Those are the extra long zip ties that you see were put into a position where it could be used like a handcuffs left on the floor, because they never got that far with that set of zip ties. And at 9:30 the next morning, the defendant is back to picking up the co-defendant and headed to Lowe's. And they're headed to Lowe's. They're not going to be thwarted from getting into that house. Nothing is going to stop them from going through that house looking for riches that don't exist. And they show up that next morning at about 11. And they show up in that DT vehicle, and you'll remember Mrs. Nyhouse, who's walking her dogs, says, I noticed a sound, and I wasn't really, it's just a weird vehicle sound. And, I look over,
And I would have called the gas company too. I would have called and said, 2 guys were just out here. Is there a gas leak? And probably would have had to leave a message and have them call me back, but still, because that's something that you could verify before you let the gas company in your house. Even if you had to do it the next morning and say, wait there on the porch and shut and lock the door, and then call the gas company while they're on your porch. She even said, didn't someone testify that she said that she was suspicious and she shouldn't have let them in, and her husband would still be alive if she listened to her instincts or something? I feel so bad for her because she was suspicious, It's awful. You should there's a podcast called My Favorite Murder, and one of their catchphrases is fuck politeness. Because that's how people get killed, by being nice and polite to people. Someone comes up to you on the street and asks for directions or whatever. If you've got a gut feeling that it's not right, F politeness. Just because it could save your life. You don't have to be nice all the time to people. If it sounds like it's, or feels like it's not right, it might not be. Who cares if you're not polite? Oh, I don't know if ours does or not. We have a number to call that we can report, power outages, but I don't know if there's a number where we could talk to a real person. I know! I didn't like saying it. I paused before I said it. I'm quoting somebody else. I only said it once. I said F after that.
finally see this slow rolling vehicle, but it's marked with DTE. And at that point, I wasn't concerned anymore, because I figured they were there just going through the neighborhood. Yes, they were successful. They had tricked the neighbor into thinking it was a legitimate DTE vehicle. So now they get out of the vehicle and go up to the Murray's home to trick them to get into the house. And unfortunately, this time it worked. And you'll hear how, once again, Hernandez is leading the way through that door. And you heard again how they're saying they're there for a gas leak, which doesn't exist. And then you hear that once they get into the house, they want to get down into the basement. For some reason, they think the safe is down in the basement. So once inside the house, as you hear, Mr. Murray goes down first, the co-defendant goes down second, and then the defendant is following behind. And Mrs. Murray doesn't think anything is off at this point. She goes back to the kitchen to continue making breakfast. She says she's there 10 or 15 minutes, doesn't hear anything from downstairs, doesn't hear a commotion, doesn't hear a scream, doesn't hear anything. And as that 15 minutes goes by, she's finished with her breakfast making, and Up comes defendant Hernandez first. And defendant Hernandez comes up from downstairs. They're close to each other, and he starts immediately, where's the safe? Where's the money? Where's the jewels? Now, it's instantly apparent that this is no longer a DTE visit. And she starts saying, we don't have much cash. I got $300 that's in my purse. Where's the safe? We don't have a safe. There's no safe here. Where's the jewels? There's no valuable jewelry here. He continues asking about that. And within seconds, up comes Zuazo, as she said. There was a very brief time period difference, not very long at all. And as she's asked about where's my husband, Zuazo shows up. And she says, where's my husband? And he says, well, he's sleeping. And then she sees the blood on his front of his shirt that he's wearing. And she immediately starts screaming. And what does the defendant do? He hauls off 6'5", 450 pounds and punches her on the left side of the face. You saw her injuries that were later photographed. That's a real hit. Are you going to keep screaming? No. So then what does he do? He starts to duct tape her. The larceny is still going. The larceny isn't over. They got a gun off of Mr. Murray down in the basement. They got his gun, we know that. And defendant Zuazo goes upstairs and starts ransacking because they're still looking for things to steal. The defendant is going through her purse, taking cell phones, taking cash, going through kitchen drawers to find those things. Larceny's not over. He doesn't go running out of the door. Zuazo doesn't go running out of the door saying, this is over, this is ridiculous. No, they're continuing with the plan. And that plan was, as you saw in the text messages, the defendant wants to buy a house with what they expect to get from this larceny. They want to buy a house. They don't want to work hard and save up for it and do all the things that you have to do to be able to buy a house. They want to go in there and steal for a house. They want to go in there, and if it takes ending Mr. Murray's life to get that money for a house, so be it. And as you hear, she's getting duct taped up by the defendant. Zuazo comes down with the drawer of jewelry. And then what? You think that it's over then? No. They both want to put her in a closet before they leave. Let's put her in the closet. And they try to put her in the closet. And they're not able to put her in the closet because of the way she's taped up. So she's left there without her cell phone, and they leave. And as soon as they leave, they continue doing what they want to do from the beginning, which is to get away with it. So they take that truck down to Detroit, because that's direct evidence. They're in that truck. There's probably going to be DNA left in that truck, and they set it ablaze. That truck goes on fire. And then you see the vehicle being followed by the defendant's wife within minutes to where the truck is found blown up within minutes, because he's still trying to get away with the larceny. So as the investigation continued, the sheriff's department very quickly, very wisely put out that video to the media, and that video went out on the media quickly, and the defendant was quickly identified as being one of the two people in it, physically distinctive. And as they do that, they start figuring out what vehicles are registered to him, where does he live, does he have any other residences, and they figure out his Jeep, they figure out the Texas residence, they figure he's gone from where he was staying up here with his mother-in-law. That mother-in-law who identifies him as being the other person in the Ring camera, and then also identifies him as being on that Lowe's video. She did that in front of you. She's never had the opportunity to see the Lowe's video before. She identifies both defendants an hour before this. At that point in time, they're stopped in Louisiana. Louisiana takes everything into evidence, and at that point, you hear when it's brought back all the things of significance that is in there from Louisiana. You find the size 13 shoes, boots. that belonged to him, and you see 2 pairs of 13 sneakers that weren't connected to this. So he has 3 pairs of 13, and on the bottom of those 13s, you'll see blood was discovered, and then you'll see that he's collected a lot more of the evidence that didn't even belong to him. He has Zuazo's boots. You know, he's probably tasked with destroying some of the evidence, and he's keeping that. Is he keeping that to negotiate something down the road? Who knows? But he kept it. He still has the DT clipboard. He still has the DT sign. He still has the POCO license plate. He has all these items with him, including the stolen jewelry. So, what you see down in the basement, which is absolutely brutal, what you see down in the basement is, and I think very obvious, that Mr. Murray was putting up a struggle. Okay? The only blood that's ever found is Mr. Murray's blood. There's no blood of the defendants. There's DNA of the defendants, but it's not DNA from blood. But he's struggling. And when he's struggling, no matter how big or small either of the defendants are, when you're struggling, they had to bind his hands. They had to bind his mouth. And they bound the hands with both duct tape and those zip ties. And why it's important, and I think it shows, not just because the doctor said the blood is in his lungs, which means he's bleeding. So there's already been that physical altercation, and he's bleeding and inhaling it. That doesn't happen if you're already dead. You don't breathe and inhale once you're dead. And at that point in time, you see very clearly in the photos, that Rolex is bound underneath those zip ties. It's bound in a way that even the ME said no, that it was secured under those zip ties. Because Hernandez likes the Rolexes. We know that, coincidentally. If he could easily have gotten that Rolex off, that would have been the most expensive item to take from that scene. But he wasn't able to do it because there was a struggle going on. You heard the multiple blows that Mr. Murray sustained in multiple areas of his head, of his face, consistent with the butt of a gun that never found that was taken out of there. The money was never recovered. The cell phones were never recovered. But what was recovered was the defendant's t-shirt, XL6 size, that has the victim's blood on it. What was recovered was the duct tape rolls in the basement that has both defendants' DNA on it. And the other thing that you can't escape, defense is going to have a closing. I don't know what they're going to say, but you can't escape saying he's not part of that bloody scene. He wasn't upstairs when that happened, because if he's upstairs when that demolishing of Mr. Murray occurs, there isn't going to be Mr. Murray's blood on his t-shirt. There isn't going to be Mr. Murray's DNA on the bottom of his shoes. And you also heard from the crime scene that they took kind of a special type of thing to uncover any type of blood evidence that was down there. This is admitted into evidence. I'll show you what's been marked as and introduced into evidence. Exhibits 3K, 3O, and 3M. The black 13 Nikes from both sides. But look at that distinctive pattern on the bottom. That is unique. That's unique to the eye. Now there's blood found on these shoes. And that's the victim's blood. But to say he's not down there when this occurred, Exhibit 2AA and 2BB. Look at that pattern that's left on the bottom of that floor. The unique ridge line on the side of those shoes on the bottom. I'll have an opportunity to address you after Ms. Lofton is finished, but I appreciate your attention.
Go ahead, Sullivan.
Good afternoon. It is quite clear that you have been an attentive jury and you've paid attention to all of the evidence and taken notes when you felt it was appropriate. So I'm not going to stand up here and go over every single thing that we have heard in these last 3 long days. But it is important to go over a number of things that you heard and some things that you didn't hear. Since it's the prosecutor's burden, as he just mentioned, he gets to speak to you twice. So I apologize in advance for my long-windedness, as I only get to speak to you once. We have told you many times that you, as juror members, are here to piece together what happened on October 11th, 2024 in the city of Rochester Hills. As you were told in voir dire, the prosecutor must prove each and every element beyond a reasonable doubt. The prosecutor carries a very heavy burden. This doubt can be created by the evidence presented, but also by the lack of evidence that the prosecutor brought forth. Now, we saw a ring the evening 2 individuals came to the Murray's home and asked to come inside to look for a gas leak. They were turned away. We also know from ring camera footage that the following day, in the morning at 11:22, the same individuals returned to the home, and this time they were let in. We know from the garage ring footage that these 2 individuals left at 11:41. So we are talking about 19 minutes. We also know that the 911 call was placed at 11:47. We heard from Deputy Copeland and actually got to watch his body camera. He was the first responder. You can tell from that body camera that he responded and got out of his car at 11:54 a.m. Officers do not enter that basement until 12:08 p.m. He, in fact, does not check for a pulse until 12:13, after saying, "I know it's silly, but what the hell? I will check for a pulse." The paramedics arrived even minutes after that. He testified, and you could hear from the comments that were being made on his body-worn camera, that he believed that Mr. Murray was shot in the head, which is usually an untreatable situation. We know from Dr. Sean O'Brien, the medical examiner, that Mr. Murray was actually still alive after the assault occurred because blood was found in his lungs, and also based on the fact that there was a large amount of blood found on the floor around him. And as the doctor explained, his heart was still pumping. It was 30 minutes from the 911 call until someone attempted to render aid. Another important detail from Deputy Copeland were his comments that he found blood on the wall and the handrail leading to the basement. This blood swipe is very similar to the one that we heard and saw that was located upstairs near the bedroom. And who did we find out was the only person that went upstairs? Mr. Zuazo. We heard from Valerie Myra, the forensic lab investigator. She was responsible for taking the photos and assisting in the processing of the scene. She told you that when collecting evidence, you never just toss it into one bag because it ruins the integrity of the DNA. She also said that when you have wet items, you put them in paper bags. You don't put them in plastic bags. She took all of the pictures of the scene and then also did some fingerprint analysis back at the lab. Now, she did photograph that swipe, that blood swipe upstairs. She was not directed to it and didn't see it or photograph the one down by the basement. We heard from another forensic lab investigator, Sierra Ramirez. She detailed her impressive academic achievements to be able to hold the position that she does. Now, she was in charge that day on collecting the evidence at the scene and then processing a number of the items for DNA. She explained that when you're collecting evidence, you need to wear gloves and wear a mask to prevent any type of DNA transfer or degradation of the DNA. You saw her not even wanting to open the package that Mr. Petrofessa handed her without gloves and a mask. She said, "It is very important when collecting evidence that you put everything in separate bags. She also described that if something has a biological substance on it, like blood, and that item is put next to something that is dry, DNA can transfer. Was Mr. Hernandez's DNA on the rolls of duct tape? Yes, we know he purchased the rolls of duct tape. Mr. Hernandez's DNA was also found on a number of items that were found in the back of his car after he handled them and packed them into his car. We also know that he packed all of the items that Mr. Zuazo was wearing in a bag found in his trunk. Now, I heard some testimony from Thomas Keelan, the individual that worked, and he testified his truck was Mr. Hernandez was responsible for stealing the car. He's not charged with that. The fact that the truck was stolen does not satisfy any of the elements of the charges that he is on trial for. We also saw and heard from multiple witnesses saying that the truck was burnt. It was driven to Detroit that same day and burnt out. Again, Mr. Hernandez is not charged with anything related to the damaged vehicle. The burning of the truck does not satisfy any of the elements of what you are here to decide. We heard from Brian Broad, that was the former boss of Mr. Zuazo. We heard that he identified him from a video that was played on the news and the social media, and he immediately called the police. He also testified that Mr. Zuazo was let go due to poor performance and not following the rules, and tell him he was going to kill him. We heard from Deputy McCoy and the detective Casey Jones from Louisiana that Mr. Hernandez had an address in Katy, Texas, and that a be on the lookout was put out in the United States, and he was pulled over in Louisiana in a white Jeep. You heard that when he was pulled over, he complied with everything that was asked of him, and he pulled over immediately. We heard from Hannah Hussein. She's a family member of the Murrays and has been a store employee at that pawn shop for 20 years. She told you that in 22 and 23, Mr. Hernandez pawned items at the store that was owned by Mr. Murray. She described that in January of 2024, someone came in and redeemed the items that Mr. Hernandez had pawned. She couldn't say who that person was, but someone came in. She also told you a story that had never been previously told to police or written in a statement. Even though she agreed with me, it was an important detail. She told you at some point, which she does not know when, she remembers Mr. Hernandez entered the store when she was working and asked about a Rolex, and then asked to talk to the owner, Mr. Murray, for 20 years, and testified that on some days, she sees 50 people. In reviewing her testimony in the jury room, I ask that you review the judge's instruction on credibility. If we are to believe that that happened, and Mr. Hernandez had an interest in Rolex watches, I understand Mr. Petrofess's explanation of why, that Rolex would not have been left on Mr. Does the fact that Mr. Hernandez went into the pawn shop owned by Mr. Murray in October of 2023 prove any of the required elements? I say no. Even if you believe that he went into the store in January of 24 to redeem his items, it does not prove any elements. There is no evidence to show that he had somehow been following Mr. Murray for over a year. Now, we heard from Linda Murray, and I think that Mrs. Murray did the absolute best job she could testifying. Definitely the worst day of her life. Now, she told you that on the night of October 10th, she yelled down to her husband asking if he had his gun on him. If we are to believe that she said that loud enough for Mr. Hernandez to hear, does it make sense that they would come back the next day with no weapon? Especially not if the plan was to injure Mr. Murray. Now, she told you that she never saw any type of weapon from either Mr. Hernandez or Mr. Zuazo. Another interesting detail she mentioned was that Mr. Zuazo went downstairs with a mask. He had it on his face. But when he came back up, he didn't have a mask on. So whatever happened in that basement with Mr. Zuazo, it caused him to lose his mask. Not Mr. Hernandez. He still had his mask on. Would a man that is 450 pounds be able to do the assault that we saw the results of and walk back upstairs with that same respirator mask on? I argue no. The most important part of her testimony in relation to Mr. Hernandez was the proximity in which Mr. Hernandez was to her for about 10 minutes of the time that he was in that home. All of the close interactions that she described happened after Mr. Hernandez had come up from the basement. She told you that he used his arm to grab her and take her to the kitchen. She told you that she watched his hands as he took off her watch, as he took her phone, as he went through her purse, as he went through the drawers in the kitchen. She was within inches of him as she watched his hands put duct tape on her wrists and on her ankles. She never saw one drop of blood on him. Not on his mask, not on his hands, not on his vest. No blood was smeared or swiped on her when he did all of those things that required him to make physical contact with her. You saw the amount of blood that was in the basement. If Mr. Hernandez did the assault on Mr. Murray, there would have been more blood on him. You saw in the autopsy photos the amount of blood that was on the face when someone used duct tape to bind him. I argue it would be impossible for Mr. Hernandez to be blood-free on his hands if he was the one that did that. Just look at the swipes of blood left by Mr. Zuazo. Now, we then heard from Detective Wiegman. He is the one you saw in the interview of Mr. Hernandez, but also the detective who testified that he talked to Mrs. Murray pretty consistently for over a week and compiled his understanding from the interviews with her. I actually read from his report, and he agreed with all of the statements in it. He stated that Mrs. Murray had told him that Mr. Hernandez came up from the basement and began to ask for money, jewelry, goes through her purse, takes her phone, that there was a period of time where this happened before Mr. Zuazo came upstairs. Now, once Mr. Zuazo comes upstairs, Mrs. Murray sees the blood on him and screams. This timeline fits exactly with what Mr. Hernandez says in his interview. And obviously at the time of his interview, he had no idea what had been reported to the police. But he tells the detective, everything was fine until Mr. Zuazo comes upstairs and he has blood on him. Now, we saw a lot of text messages today that Mr. Hernandez exchanged with his wife and with Mr. Zuazo. In all of those hundreds of text messages, nothing about a gun, nothing about a weapon, nothing about killing. Now, conversations about an elaborate larceny? Absolutely. Conversations about taking things that weren't his? Yep. But Mr. Hernandez does not have a charge that you are here to decide that is alone called larceny or home invasion. Now, we heard from the medical examiner, Dr. Shauna Bryan, and she told you that Mr. Murray did not die of a gunshot wound, which was previously thought, but actually, he died after being beaten in the head and the neck. She told you that blunt force injuries could have been from an object, or a fist, or some of them could have even been from a fall. That while the injuries were severe, they could have been done by someone that was just 150 pounds. She also testified it takes 6 pounds of force, or as she described, the weight of a human head, to compress the neck to stop breathing. This definitely could have been done by one person. Now, after his arrest, Mr. Hernandez did not have to talk to the police. As you know, Mr. Zuazo did not. He could have remained silent, but he didn't, because he wanted the deputies to know that he was not part of the beating of Mr. Murray, and he wanted to tell them that. Now, it's usually not appropriate to talk about someone's size, but because it's been such a topic of conversation here, let's talk about it. Remember the video of the interview in Louisiana. At that time, my client was booked into the jail at 450 pounds. As you could tell from those Lowe's videos, he had some trouble walking, and if you watch at the end of that interview, he could barely get up from the seat. Now remember back to the photos of where Mr. Murray was found. That space is extremely small. I argue that there is no way that Mr. Hernandez could have been the one attacking Mr. Murray. One, I don't think he's physically able to, and keep his mask on. And two, there wasn't room. Now, Mr. Hernandez was open and honest about the fact that a truck was stolen, signs were made, outfits were purchased, forms were printed out, badges were made, clipboards, duct tape, zip ties. They bought hard hats. We saw them at Lowe's and Home Depot. All in elaborate preparation of a larceny, not a murder. You did not see them at a gun store. You did not see them buying weapons of any sort. That is because it is clear from the evidence and clear from what Mr. Hernandez kept saying in his interview. It was not supposed to happen. Mr. Murray was not supposed to die. For that whole hour, Carlos kept the same tone, the same mood, until he was asked one question. If you killed the husband, why would you leave the wife alive? It was not supposed to happen. There was never a plan to kill Mr. Murray. If there was a plan to kill, why would you need to bind someone with duct tape? If someone is dead, they don't need to be bound. Think about that. They chose to walk in with tape instead of a weapon. Does tape show intention to kill? I argue no. Dr. Bryan told you that the duct tape on his hands and feet and mouth did not kill him. If there was a plan to kill, once the gun was removed from Mr. Murray by, I believe, Mr. Zuazo, why wasn't he shot? Why then wasn't Mrs. Murray shot? Now let's talk about the mention of an insurance policy in the interview and the correlation to the black bag found in Mr. Hernandez's Jeep. In that black bag, we were told Mr. Zuazo's boots, gloves, hat, and 2 masks were located. DNA clearly shows that those items were his, and they match what he wore on the Ring camera. Now, how did Mr. Murray's DNA end up on the large white t-shirt and the shoes of Mr. Hernandez? Well, unfortunately, Mr. Hernandez does not have the years of training regarding biological substances like the evidence technicians. Mr. Hernandez's own clothing was found in the same plastic bag as the bloody items from Mr. Zuazo. We learned about DNA transfer and degradation. If Mr. Hernandez had blood on him, Mrs. Murray would have seen it. I asked you in voir dire if you understood that you were not here to decide if Carlos was a nice guy, if you'd like to have him as a neighbor, or if you'd like him to have him date your daughter. Do you remember that question? And why is that important? Because again, even if you don't like him, none of the elements are satisfied by that fact alone. You may not like any of the actions that Mr. Hernandez took leading up to October 10th, on October 10th, or October 11th. The fact that he did some bad things does not then automatically mean that he committed the acts for which he is charged. Now I want to talk about the actual charges now. So we know the first count is first-degree felony murder. To prove this charge, the prosecutor must prove each and every one of the following elements. First, Mr. Hernandez caused the death of Hussein Murray, that he died as a result of neck compression and blunt force trauma. Second, Mr. Hernandez had one of the 3 states of mind. He intended to kill, he intended to do great bodily harm, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Mr. Murray, that Mr. Hernandez was committing or attempting to commit or helping someone else commit the crime of larceny. As we all know, after the end of 3 days, a larceny is a taking of property with intent to permanently deprive the owner without consent. Now, did the prosecutor prove to you beyond a reasonable doubt that it was Mr. Hernandez that caused the death of Mr. Murray? I argue no. The prosecutor now gets 2 bites to this apple here. They are either arguing that yes, it was Mr. Hernandez who actually did the beating death of Mr. Murray, or if you don't believe that, then he is still guilty under aiding and abetting. This instruction is so important and actually very helpful to you when you go back in that jury room, so I want to go over it. The judge is going to tell you to prove the theory of aiding and abetting. The prosecutor must prove all of the following elements beyond a reasonable doubt. First, that the alleged crime, which is felony murder, was actually committed either by Mr. Hernandez or someone else. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. And third, which is the absolutely most important element, third, at the time, Mr. Hernandez must have intended the commission of felony murder, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Was murder a natural and probable consequence of the commission of larceny? I argue absolutely not. And because of that, you have to find Mr. Hernandez not guilty of felony murder. These two individuals did not bring a weapon. They walked in the home with fake DTE equipment and duct tape and zip ties. Death was not the natural and probable consequence of those actions. It is clear that Mr. Hernandez went into that house, could make some fast cash and get a house. There has been absolutely no evidence that Mr. Hernandez went there with the intention to kill anyone in that home, and because of that, I argue felony murder was not proven. Now, Mr. Hernandez is also charged with 2 counts of unlawful imprisonment, as we discussed in openings in voir dire. There's 1 count as to Mr. Murray, 1 count as to Mrs. Murray. The elements are the same. For count 2, unlawful imprisonment against Mr. Murray, I do believe that the prosecutor has proved the elements of this charge under the aiding and abetting theory we just went over. Mr. Hernandez went into the house after purchasing duct tape and zip ties that he shared with Mr. Zuazo. I believe the evidence then shows Mr. Zuazo used those items to restrain Mr. Murray. The binding of Mr. Murray was a natural and probable consequence of him walking in there with that tape. 3, unlawful imprisonment against Mrs. Murray. I do believe that the prosecutor has proved the elements of this charge. The test.
Well, that's different. Stupid StreamYard. As I was saying, can y'all hear me? Stupid StreamYard. As I was saying, that's different. Get up there and say, oh yeah, the prosecutor proved their case on this charge and on this charge. I don't think I've ever seen that happen before. So she knows that there's no way she's going to get him off on the other charges. She just wants to make sure she gets him off on the murder charge. Good strategy, though, because she's not going to get him off on the other charges. Yay, Carla. Thank you so much for supporting the channel, and thank you so much for the 5 memberships. I appreciate it. I still cannot believe that I've had members for 7 months. Doesn't seem like it's been that long. Thank you so much. I appreciate all your support. You are so awesome. Always shouting out my channel, giving gift memberships. You're amazing. Thank you so much. I don't know why, but I've got the channel pulled up on my laptop, but I don't have chat, so I can't even see who got memberships. I don't know what's going on. The past 2 weeks have been a blur, and I am so exhausted right now. I'm gonna sleep all weekend. So yes, welcome new members, whoever you may be, because I have no idea.
Testimony of Mrs. Murray indicates that it was Mr. Hernandez who used duct tape on her wrists and ankles prior to leaving the home. The verdict form will not say guilty or innocent. The verdict form will say guilty or not guilty. are voting not proven, that the prosecutor has not proven his high burden. I ask on behalf of my client, Carlos Hernandez, that you return a verdict that is consistent with the law, consistent with justice, and a verdict.
You guys can't hear that, can you? I forgot to fix the... Hang on. I forgot to fix it.
Of felony murder, or must have known
Told you I was
that
tired.
the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Was murder a natural and probable consequence of the commission of larceny? I argue absolutely not. And because of that, you have to find Mr. Hernandez
Welcome, new
not
members.
guilty of felony murder. These two individuals did not bring a weapon. They walked in the home with fake DTE equipment and duct tape and zip ties. Death was not the natural and probable consequence of those actions. It is clear that Mr. Hernandez went into that house thinking he could make some fast cash and get a house. There has been absolutely no evidence that Mr. Hernandez went there with the intention to kill anyone in that home, and because of that, I argue felony murder was not proven. Now, Mr. Hernandez is also charged with 2 counts of unlawful imprisonment, as we discussed in openings in voir dire. There's 1 count as to Mr. Murray.
Her voice is kind of harsh. I'm not trying to be mean. I'm just saying, like, she needs to work on her delivery. Like, she needs to talk to them, not, like, read to them. You know what I mean? Like, she needs to be more personable. Like, more like, we're doing this together. We're a team. We're, you know? I think it would go across better with the jury.
1 count as to Mrs. Murray. The elements are the same. For count 2, unlawful imprisonment against Mr. Murray, I do believe that the prosecutor has proved the elements of this charge under the aiding and abetting theory we just went over. Mr. Hernandez went into the house after purchasing duct tape and zip ties that he shared with Mr. Zuazo. I believe the evidence then shows Mr. Zuazo used those items to restrain Mr. Murray. The binding of Mr. Murray was a natural and probable consequence of him walking in there with that tape. I believe the prosecutor proved that to you. As to count 3, unlawful imprisonment against Mrs. Murray, I do believe that the prosecutor has proved the elements of this charge. The testimony of Mrs. Murray indicates that it was Mr. Hernandez who used duct tape on her wrists and ankles prior to leaving the home. The verdict form will not say guilty or innocent. The verdict form will say guilty or not guilty. And by voting not guilty, you are voting not proven. That the prosecutor has not proven his high burden. I ask on behalf of my client, Carlos Hernandez, that you return a verdict that is consistent with the law, consistent with justice, and a verdict that is supported by all of the facts and evidence that you have heard in the last 3 days. And that would be a verdict of not guilty as to count 1 and guilty as to count 2 and 3. Thank you very much.
Thank you, Ms. Laughlin. Any rebuttal here?
I don't think I've ever heard an attorney do that.
Again, defense counsel starts off with talking about a plan to kill when they arrived at the house. That is not what felony murder is. That's first degree premeditated murder. That's not how you're going to be instructed regarding the elements to be proven in this case. I would also say that there's a couple definitions that I maybe take issue with or need to be amended after this case has gone through. The first one would be forthcoming in describing the defendant's statement to the Oakland County Sheriff's detectives. What I heard, and I think it's only got little worth, but I don't think it was very forthcoming when he was talking to the detectives. If you recall, which I thought were the highlights of it, defendant says, when he's supposed to be forthcoming with the detectives, he says, "I never said I was there the second day. I never said I was there the second day when all the bad stuff happened." At that point, he's trying to portray himself as only being there on the 10th, where nothing really bad happened. That was forthcoming statement number one. Then you remember he was asked about Mr. Murray fighting back. There was no response to that question at all. Silence. He doesn't want to talk about what happened in the basement with Mr. Murray. And then, shocking, he says, when asked about hitting Mrs. Murray, he says, I don't recall hitting Mrs. Murray. That was another one of his forthcoming statements that he made to the police officers. And the final term that I would change is that this was an insurance policy for him, because what he had in that black bag was anything but an insurance policy for him. Now, there was a statement about his mask not being in place and there should be more blood on the defendant. More blood, we need more blood. Well, you hear from the first deputies on scene that they're reporting as a gunshot wound. That's how much blood there is at that scene, that they believed it was a gunshot wound. That's how much blood was there at the scene. We need more blood? Okay. Well, the facts give you more blood. As you heard the testimony, you have the exhibits for the defendant, C and D, that are moved into evidence. In the stuff that's found with them, face covering N95, red stain on the exterior. Defendant Hernandez on the interior. Both victims on the exterior of that. Defense wants more blood? Okay, well, 7E, white t-shirt, which is into evidence before you. Swab both the inside and the outside. Defendant Hernandez on that 6XL t-shirt is in the interior. Victim Sam Murray is in the exterior of that exhibit. More blood still? We've already talked about it. Those black Nikes. But not only is there the blood of the victim on the outside of those shoes, the blood of the victim and his DNA is inside the shoe also. That's how intimately connected the defendant is with that bloody scene. And then finally, as we also discussed, 7G, the black gloves that were found on the defendant when they were stopped. Exterior victim of the victim. Interior is defendant Hernandez. Also interior is victim Linda Murray. So, I guess the best response I can have about trying to have it both ways, I believe that was said at some point. At no point have I ever theorized that only one of the defendants obliterated Mr. Murray in that basement. I don't believe only one of those defendants had contact with him when this was occurring. I believe both defendants had contact with him down in that basement when he put up that struggle, because they have to disarm him. And disarming him first is probably one of the main priorities. But then he's attacked from the back and his head is bleeding. Now, I tried to think about, a response to that, but growing up, I have a brother, he's 4 years younger than myself, okay? So growing up, for a long time, I was the older brother, and when we roughhouse and play around and wrestle and stuff like that, I could get both of his arms, his wrists in one hand and hold him down with one hand and a second hand free to tickle him. I don't know what you want to say, but you could hold both arms in one hand. When he got older, I couldn't do that anymore. And if we were going to struggle, it would take a hand in each hand to do it. Now, Mr. Murray is a big guy. Mr. Murray is struggling. There's no way that you're holding down Mr. Murray as he's struggling with one person and then binding him in that position. There is no way one hand is holding him with one hand and tying him with duct tape with the other, with zip ties. Impossible. Both of those guys were doing that down in the basement. They have the blood of the victim on it to prove it. You don't get blood on you like that if you're upstairs with Mrs. Murray asking about where the safe is. I believe the evidence has clearly shown that the defendant is guilty of charged of the murder and of the other 2 counts. I appreciate your time and attention. Thank you.
So what do you guys think? I kind of thought that Carlos didn't do the murder, but it doesn't matter. Because if they hadn't broken in and done the home invasion, nobody would have died. So it doesn't matter whether he actually did it himself or not. The fact that they were there robbing them caused him to die, so it doesn't matter. It's not first degree premeditated murder, it's felony murder because someone died during the commission of a felony. A long time ago, I don't remember where it happened or what the kid's name was, but there was a kid. He was an adult, but his grandfather was
Arguments
abusive.
in this case are finished. I will now instruct you on the law. That is, I explain the law that applies to this.
And he was an adult, but still a young adult, like, late teens, early 20s. And he and his little sister lived with his grandfather. And he unalived his grandfather to protect his little sister. But he robbed him he took money out of his wallet when he did it. And if he hadn't have done that, he might have been fine. But because he stole the money, he went to prison for felony murder. Because he stole in the process. And that seems like unfair, because the reason that he unalived him was to protect his sister. But the robbery turned it into a crime. Hey, Jill.
Case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinion of the other jurors who might have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given some instructions about the law. You must take my instructions all together as the law you are to follow, and you should not pay attention to some instructions and ignore others. To sum it up, it's your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes sworn testimony of witnesses, exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'm going to describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and commentary are also not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are not evidence, and you should only consider these questions as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during trial, I've excluded evidence that was offered or stricken testimony that was heard. Don't consider those things in deciding this case. Make your decision on only evidence that was let in and nothing else. Your decision should be based on all the evidence, regardless of what party produced it. And you should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge that you have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I've said before, it's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you have based on a witness's disability, race, national origin, or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be an automatic or instinctive judgment and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did this witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with all the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. And if so, you may choose not to accept anything the witness says. On the other hand, if you think the witness has lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that this crime occurred on or about October 11, 2024 in Oakland County, Michigan. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in this case. You may consider the statement in deciding the facts of the case. Water break. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. But facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that's circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial and direct evidence, can be used to prove the elements of the crime. In other words, consider all the evidence that you believe. There's been some evidence that the defendant ran away after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. You have heard evidence that before the trial, a witness made a statement that might be inconsistent with their testimony here in court. You may consider an inconsistent statement made before trial, but only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. When the lawyers agree on statements of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, think about what each witness and each piece of evidence and whether you believe them. Then you decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from witnesses who have given you their opinion as experts. Experts are allowed to give opinions in court about matters that they are experts on. However, you don't have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. And when you decide whether you believe an expert's opinion, think carefully about the reasons and the facts that they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about all the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. As to count one, the defendant is charged with the crime of first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death, or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, at the time the property was taken, the defendant intended to permanently deprive the owner of that property. The defendant must have been either committing or helping someone else commit the crime of larceny. To help means to perform acts or to give encouragement before or during the commission of a crime that aids or assists in its commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or someone who he aided or abetted caused the death of Hussein Murray. That is, that Hussein Murray died as a result of neck compression and blunt force trauma. Second, that the defendant or someone that he aided or abetted had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Hussein Murray, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that the killing was not justified, excused, or done under other circumstances that reduce it to a lesser crime. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that's likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. As to count 2, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, the defendant knowingly restrained Hussein Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with a person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. As to count 3, the defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, the defendant knowingly restrained Linda Murray. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, that the defendant did so under one or more of the following circumstances. The restrained person was secretly confined, which means to keep the confinement or location of the restrained person as a secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. In this case, the defendant is charged with committing first-degree felony murder and 2 counts of unlawful imprisonment or intentionally assisting someone else in committing it. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. If the defendant knew that the
That's it? 4 years? How come I keep seeing, I get all this stuff keeps popping on my phone about how his lawyer's crying and upset because of his sentencing. He doesn't like his sentencing. 4 years? That don't sound too bad for all that he did and got away with. Jeez. Crybaby.
Alleged crime was planned or was being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. When you go to the jury room, you're going to be provided a copy of the written final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business way and that everyone has had a fair chance to be heard. During your deliberations, please turn off cell phones or other communication equipment until we death. A verdict case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss this case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. I've already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you can consider the lesser offense. It's up to you how long you take to decide or consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense after discussing the lesser offense if you want to. If you have questions about jury instructions before you begin deliberations or questions about the instructions that arise during deliberation, you will submit them in writing in a sealed envelope to the
He
court.
actually cried?
Possible penalties should not influence.
I thought that was like a figure of speech when it popped up on my phone. I didn't know they meant he literally cried. Oh my God. Good Lord.
Your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court clerk. It's not proper for you to talk directly with me, the lawyers, court officers, or anyone else involved in this case. As you discuss this case, you must not let anyone know, even me, how your voting stands. Therefore, until you reach a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want.
Okay, well that makes it a little bit better that it was a she.
Want to look at any or all the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you're going to be given a written copy of these instructions, as I've already told you. My instructions together are the law you are to follow. The defendant is charged with 3 counts. That is, with the crimes of first-degree felony murder and 2 counts of unlawful imprisonment. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in this case. You may find the defendant guilty of each or any one, any combination of these crimes, guilty of a lesser crime, or not guilty. A verdict form has been prepared, and the verdict form is going to have the title and case number on the form, and the verdict form is going to list each count, and I'll read it to you. Count 1 says first-degree felony murder. There's a box to check, the first box that says not guilty. The second box says guilty as charged of first-degree felony murder, and the third box says guilty of the lesser offense of second-degree murder. Count 2 is unlawful imprisonment. The first box says not guilty. The second box says guilty as charged of unlawful imprisonment. Count 3 is unlawful imprisonment. The first box says not guilty, and the second box says guilty as charged with unlawful imprisonment. You are to check the box as you reach your verdict. The foreperson shall sign and date the verdict form. All right, so those are all the formal instructions. Let me just kind of give you some procedural information at this point. So when you are taken back to the jury room, you're going to be given a buzzer, and that's the way that you're going to be able to communicate with the court. So anytime you want to communicate with me, you would write it in a note, put it in a
There's
sealed
no
envelope,
larceny charge?
and then that information is brought to me.
Or
I'll explain that
home
process in a
invasion,
minute.
or-
But with the buzzer, that's the way that my staff's gonna know you need them, and if you do press that buzzer, someone will come to the door, knock very loudly, and say, stop all deliberations. That is because they want you to stop your deliberations, so please stop talking when they come in to get that note. They don't wanna be in your deliberations, so please don't ask them questions, don't hand a question to them and say, this is what we want the judge to know, okay? They will certainly bring that note over to me, it is read by me, and then depending on what the question is, it is answered, okay? All questions are answered. Here's the things that we are not gonna bring you back into court to answer. I don't manage your time, so if you go back there and you need a break, I know you guys had a long break today, but if you need to take a break, and you're taking a break within your own jury deliberation room, I don't need to know that, no one needs to know that. The only time I need to know is if you're taking a break and you're leaving your deliberation room. So in that case, write a note, let me know, Judge, we're gonna take a 20-minute break and we wanna leave this room, and somebody will come back to let you know if you are able to leave at that time, okay, or when it's appropriate to leave. If you ask for evidence, any objection having the evidence given to the jury upon asking?
No, Your Honor.
Okay, so the reason I'm asking the lawyers that is any other question that you ask outside of those breaks and the evidence are going to require me to reconvene court. So it means we all come back into court like we are now. That question is read out into the record to the lawyers, and the lawyers and I decide what the best way to answer that question for you is, and then you are brought back in here, and the question is answered in front of everybody, okay? Obviously, there's two juries at the same time, and it might take me a little longer to get back to you. It's not because we are ignoring it, it's because that process will take some time. I'm not telling you that to discourage you from writing a note, I just want you to know what's happening during that time period. So, evidence. The evidence, there's some evidence here that is sealed evidence. All right, you're allowed to look at any piece of evidence if you want to. If you're gonna ask for that specific evidence that is sealed, you're gonna need to let me know that in a note that you wanna see that. And it will be brought back to you, but then we'd also provide everyone with gloves to make sure that there's no contamination if you wanna take something out, okay? So just be specific about that. There's also digital evidence. You're not gonna have any electronic equipment to play the digital evidence unless you ask for it. So if you wanna see something digital, let me know and say, we're gonna need a device to see it. And if you're not sure, just ask for the technology and I'll get it back for you, but I can't bring it back for you unless you ask, okay? There's 14 of us, only 12 are required for a unanimous verdict in a criminal case. So we draw lots to determine which two of you are going to be excused as alternate. It's my understanding that we already have your names and your phone numbers, so you're excused. You are free to go for today. However, it is not a common practice for an alternate to be called back, but it has happened. And in the case as lengthy as this one has been, it wouldn't be out of the ordinary if you were called back. So the restrictions that I gave you originally
Lengthy,
regarding not
4
sharing
days.
with your family, not posting, not speaking to media, all of that stuff still applies. I will promise you this, okay, and we're very good at doing this. If you're an alternate and we get a verdict, you are the first call after we take that verdict. You are told that the verdict has come in, and if you'd like to know what that verdict is, we will share that with you. Okay? All right, let's two people, please.
Juror number 8.
That's you, sir. You can stay seated. We'll let you go when everyone goes back.
And juror number 5.
And that's you. Okay, all right. Thank you both for your time and service. And as I said, all the restrictions will apply until you get a call from Chambers. Okay. Anything else I'm forgetting with the
No, you're right, people are satisfied with the
Okay,
instructions.
you're satisfied? Okay, I'm just gonna go in and just swear in my clerks now. Please raise your right hand. You do solemnly swear, no, not you guys, my clerks, you do solemnly swear that, but I can see how that's confusing. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, and that you will not communicate with them or any of them orally or otherwise, except by order of this quarter to ask them if they have agreed on their verdict and how they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God. Okay, all right, thank you. Ladies and gentlemen, we'll send you back to your jury room.
All rise for the jury.
Please be seated. It's honestly it's 5 o'clock, but I'm gonna keep them a little bit later. I think that at least give them an opportunity to be able to have initial discussions and choose a fourth person. So
Yes, Judge.
I'm gonna say 5:30 or
As
6.
long as you need, Judge.
Yeah, okay, I appreciate it. Are you good with that, Ms. Lawson?
Yes, ma'am.
Okay, and I obviously understand that, everyone, it's Friday evening, okay, so I will be considerate of your time. Okay, all right, thank you.
All rise.
So that means no verdict tonight, I guess. Yeah, Jill, that's not nearly enough time because they didn't convict him on everything he was charged with. So that's why he only got 4 years, because he didn't get convicted of everything. So I guess we'll wait till 5:30 because maybe the other jury, I doubt the other juries will reach a decision by 5:30, but we can hope. Ooh. So we gotta wait all weekend. I didn't even, I know it was federal charges and we couldn't see the trial, but even if we could have, I didn't want to. Because those kind of crimes are so abhorrent to me that I don't even want to hear about them in a trial. I just, no. And from what I understand, he's not the only one in the entertainment business that does crimes like that. They need to round them all up and lock them up and throw away the key. And I don't know who all they are. I've heard rumors about some of them, but I don't know who all they are, but they all need to be taken care of. Yeah. Anybody that needs that much baby oil, I don't have any use for. I had all my life been, I guess the word would be judgmental about prostitutes. And then I saw an episode. You guys are probably sick of my TV episodes, but an episode of SVU, and it was Danielle Panabaker was on it, and she played like this girl that was going to Unork. I'm tired, you guys. She was going to New York. I don't know why. It was her dream, I guess her dream to go to New York. I don't know if she wanted to be an actress or a model or whatever. But it's been so long since I've seen it. I guess she got mugged and some guy was nice to her and gave her a place to stay and took care of her. And it didn't really say if he had set up the mugging or not. He probably had. But then he took care of her and Of course you do. And after maybe a week or so, she thought she was, the best thing ever had happened to her. She had met this rich guy and he was her boyfriend and was buying her all kinds of stuff. And then he started giving her tips. And then he started pimping her out. And then he started giving her drugs to get her to perform more and more and more. And it ended up that he was trafficking her. And then I started feeling sorry for these women. And then it dawned on me, no woman has ever, as a child, thought, when I grow up, I want to be a prostitute. These are women, I'm not approving of it at all, but these are women that something happened in their life that forced them to have to do this to survive. I'm not excusing it. I'm not condoning it. I'm not saying that they're little angels. I'm just saying no woman woke up and said, I think I'm going to be a prostitute. So I do have a little bit of sympathy for these women. Because they've gotten themselves into this position and can't get out of it. And it's people like Diddy that cause it to happen. And that is disgusting. That's just a straight up misogyny. Why would you do that to a woman? Somebody that pimps out a woman is no better than Johns that pay them. It's disgusting. You're horrible. Yeah, probably. Yeah. I don't know though. Some of those guys might think I started to say a celebrity. He is a celebrity. But some of those guys might think, oh cool, it's Diddy. We're not worthy. Yeah, like as a kid, when you're taught right from wrong, you're taught black and white. You're not taught shades of gray. And then when you grow up and you realize, because you're taught, prostitution bad. But as a kid, you don't realize how it happens. It's awful. It is awful. and imagine how many women have had that almost happen to them and they've escaped, you know? Like, you go somewhere expecting to start over, whatever, and then you're down on your luck, and some guy's like, you know, I can help you out, and then you have to escape the guy before something worse happens to you, you know? And then some women don't escape, and they get stuck. Or, for whatever reason, you get addicted to a drug. And it's not always, oh, you were at a party and tried an illegal drug and you got hooked. It's not always that either. Sometimes it's you had a surgery and you got addicted to a pain medication. And because you got addicted to that pain medication, then you ended up on the harder stuff or whatever. And, you know, like... Oh, that's funny. Yeah, and yeah, they're sex workers. They're called sex workers now. Yeah, because they don't like being called prostitutes. They're changing the name to make it more respectable. Like the ones that like OnlyFans and stuff like that. They think it's, I don't know, this might be getting to a touchy subject for some people, but they think it's okay because there's no actual physical contact. But it's still, I think it's still prostitution. Because you're still degrading your body for men to give you money, you know? Like, so the women that do that, they do those types of things. They said, no, it's sex work. We prefer to be called sex workers. Okay. That's what you want me to call you. See now this blows my mind. Not that I hold grudges, but you can just sit down and shoot the breeze with these people. They haven't been quite as hostile, though, as some lawyers are to one another. But you can just sit down and shoot the breeze with your opponents when it's all over and done with. I guarantee you that would not have happened at the end of the Karen Reed trial. My personality, I am not cut out. And, man, God knew what he was doing. I don't know why I'm surprised. Like, my Bible study yesterday was on, I haven't done my Bible study yet today. I need a bigger desk. My whole entire dining room table is covered in stuff because I need an office. Yesterday's. It was about how God is righteous, that all of his decisions are righteous. So, I had 2 career paths: nursing and law. And it has a whole bunch of verses about God's righteousness. His acts are right. His acts are righteous. Our God is righteous. God reaches to the skies. God's righteousness endures forever. His judgment is righteous. There's a bunch of different verses about God being righteous. Meaning right, meaning his decisions are right. Man, in my career track, it absolutely was. Because I sit and watch these things and I'm just like, personality-wise, absolutely not. I could not do that job. And it was always nursing first. And if I don't like it, then I was going to go to law school. And I watch this and I think, man, the Lord was right. I was supposed to be a nurse because there's no way. I don't have the personality. Number one, the first time the judge got upset with me, I'd start crying. And like I've told y'all before, I'd have to pack my toothbrush with me because I'd probably end up jail more than once. Who is the dude in the t-shirts and the shorts and the deck shoes walking around? Why did it just freeze? What, are you talking about my extra room that's full of the girls' stuff? I'm a little afraid of them, Jill. I'm afraid of what they will do if I do that. They're mean to me. Yeah. Yeah, you're right. You're right. It's not that I hold grudges. It's just that I don't think, well, it's like politeness. Like, I don't think I could stand up there and say mean things about my opponent and then be able to be face to face with them about other stuff, like, because you have to talk to each other to make arrangements for things and to discuss things about the case, and then I'm going to stand up and say, what they told you wasn't right or wasn't true or whatever, and then I'd have a hard time talking to that person face to face after I just got up and called him a liar. Because I'm too nice. I can't do that. Those girls are never gonna move out of their mom's house, Jill. They're not. They're not ever. Casey still has not got a job yet. Kristen has too. She's working at a grocery store, and she's doing the delivery thing for Walmart. I forgot what they call it. It's got a weird name. Yeah, unfortunately, some of the newer cartoons are not fit for kids to watch. When did cartoons start teaching kids about sex? I was in 6th grade, and my mom had to sign a permission slip for me to watch a movie about where babies came from. And she did not sign the permission slip. So I think I had to go to the library with a few other kids that didn't get to watch it either. And now there's cartoons on Netflix teaching kids about.
Simon, remember he was older?
Now there's cartoons on Netflix teaching kids all about everything. And from what I understand, there's a Netflix boycott. I didn't know anything about it until I saw it all over YouTube today or yesterday. Today? I don't remember. I canceled my Netflix subscription. It wasn't because of that. It was just because I don't ever watch it. I love Pepe Le Pew. I miss Saturday morning cartoons because, and I feel bad for kids that don't, because that was a special day. Really? I don't think, well, I don't know. I didn't get to see ours. I thought it was just about where babies came from. There was a movie at Disney that I loved it so much. And I said, when I saw it when I was a teenager, I said, when it comes time for my kids, which I never had, to learn, I was going to bring them and show them this movie. Yeah. See, you guys, Jill threw me a squirrel. Yeah. Saturday morning cartoons. Kids don't have that. They have cartoons 24/7. They don't have the special getting up early Saturday morning when everybody else is still asleep, parking their keister in front of the TV with the box of cereal. It made it special. Yes, it made it special. Saturday morning cartoons and Fruit Loops. It made it special. Cartoons aren't special anymore because you can watch them anytime you want to. It was a special thing. And it's not special anymore. So this movie, you had to be quiet. That's no fun. They just ignored me. So this movie at Epcot, it was at Epcot, not at Magic Kingdom. It was called The Making of Me, and it was narrated by Martin Short, and it was all about where babies came from, and he told the story of how his parents met, and then it showed how they got married and everything, and then when they were making him, he goes, come up here, I can't show you this part, and then we go up on the roof, and we're sitting on, it's like from our eye perspective, but we're like sitting on the roof with Martin Short. Well, he then explains the science of the egg and the sperm and all that, but he can't show us what they're doing in the bedroom at the time, so he's telling us the scientific part about it. And then you go down, you get to watch his mom have it. But they don't have it anymore. Oh, well, that was nice. So, they had, it was called the Wonders of Life Pavilion, and they had that movie. They had a ride called Body Wars, where they pretended like they shrunk you and you were in a spaceship, but you were inside the body, and going to this site of a splinter, so you got to see the inflammatory process and infection and thank you, honey. And so the little ship went in the lungs, so you could feel like when the lungs would breathe, and then you went in the heart, and the heart. It was really cool. The whole building, it was all about health. There were batting cages in there. You could play baseball. There was one thing we had on corn popping and stuff like that. Then there's another, it was like a show where it looked like you were inside this kid's head. Yeah, it was exactly like Fantastic Voyage. It was so cool. And then there was one where you were like in his head, and you saw the movie screens were like eye shaped. So like you were looking through his eyes of a adolescent boy. And it taught you all about, so it was like the movie Inside Out before the movie Inside Out. It like taught you about emotions and functions of the brain and stuff like that. But I guess they said it wasn't that popular, so they shut it down. It was my favorite thing at Epcot, of course, because I'm a nurse, and I loved it. It was health stuff. I loved it. It was my favorite thing there, and it's not there anymore. It's office space or something now. But yeah, that was my favorite ride at Epcot. It was just like Fantastic Voyage. It was amazing. There's so many things that they've done over the years that they just closed. And just, it's nothing there now. It's like, I don't like space that's not doing anything. It drives me crazy. It's like, put something there. Or get rid of the building and make it a pretty garden or something. Like, why is it empty space there? I don't know why that bugs me so bad, but it does. It bugs me. Like, put something there. There's a whole building at Magic Kingdom that has had 2 different, not rides, but shows, like interactive show things in it. Completely empty now. Do something with it, Disney. No, they're getting rid of things that did things to put new stuff in. How about use up some of your crap that you're not using? No. I don't know. Or running theme parks, I should say. Well, it's 5:30. She said she was going to give them to 5:30. He did not do everything I asked him to do. He did get me nail polish remover, though. But I wanted a barbecue sandwich. I neither see or smell a barbecue sandwich. Yes, it's 5:30 where I am. It's 4:30 where you are. It's 5:30 where I am. And I have to eat leftovers because he didn't bring me a barbecue sandwich. I guess I didn't achieve princess status today. All I got was nail polish remover. It looks like Pepsi. My cousin texted me a while ago. She's like, "Are we good?" I'm like, "Yeah, we're fine. Why?" Like, I've just been busy. She's like, "What trial are you doing? Because there's nothing in the news." She's like, I went to her house and stayed a week once. All they ever watch is news and politics. I got so bored. I'm like, I'm not coming back. so so boring. Like I'm not coming back. So she texts me, "What trial are you covering? Because there's nothing good in the news going on." So I told her the last three trials, including this one. I'm like, I'm exhausted. That's why I haven't talked to you. But yeah, we're good. Just haven't talked to you because I'm tired. So tired. There was something about Domino's. What did Domino's do? I told Travis the other day, I was like, oh, we can't eat at Domino's anymore. I forgot what it was.
Fired.
Oh, something about Charlie Kirk, wasn't it? I don't know. It's like a rotating door. It's like I can't like pineapple on pizza, but not every single time. That one can eat pineapple every time we get pizza. And sometimes just like, pineapple this time, Travis. No pineapple this time. I like pineapple. I don't care. Just one time with no pineapple. Let me have a break from pineapple. But it's a revolving. A company will do something stupid, and we'll be okay. Well, we can't get anything from them anymore. We can't give them our money anymore, and then their stock will go down, and then they'll correct whatever they did, and then another company will do something stupid. Well, we can't give them our money anymore. It's a revolving door. It's constant. It's like, I'm getting tired of trying to keep track of whose business I can't go to anymore. It's getting ridiculous. You know what? If Walmart or Amazon does something stupid, I'm screwed because that's a majority of what I buy from is Amazon and Walmart. Yeah, I've thought about doing the half the pineapple for him and half of whatever for me. That's what I'm gonna have to do when I get sick of pineapple, cause see my deal with the pineapple is if you're gonna do like the Hawaiian pizza with the pineapple and the ham, that's a Hawaiian pizza. But if you're gonna do flavors or just like a no pineapple on it, the pineapple is for the Hawaiian pizza. But no, he wants pineapple on it all the time. So far, I've never heard anything about Walmart doing. They're pretty good with knowing the right thing to do. Target has. Okay, do you remember Target had that the boycott because they had the Pride closed, the Pride section for kids, and so people started stop shopping there because of that, and then their stock went down, and so they got rid of the Pride section, and people started shopping there again. Well, last I heard was, why didn't you go to Burger Spot? I asked you to. I did too. I did. It was in the message with this.
I said acetone to you, said make sure it said acid.
And
That's all it says.
I'll show you. So,
Oh, yeah, yep. Did you get all that food in here? We'll have that.
So I saw something not too long ago about Pride people in the store protesting because they didn't have a Pride section anymore. And I was like, they need to learn from us. That's how you protest. You hit their pocketbook. That's how. I can prove it. He won't, when I text him, he won't click on it. He only reads what
I
pops
did click
up.
on it. And all he said, acetone, please, nail.
I want burger spot.
Oh, mine didn't say that.
I want burger spot. We need ice cream and drinks. Did you get ice cream?
I just got your acetone and 2 drinks. That's it. I know we have food here.
Click on this and look at your messages.
Vicky, I need you to order my things for me. Come on, Bill.
He only reads the part that pops up on his phone. He doesn't click on it and read the whole thing. It was separated. I put I want burger spot, and then like a few minutes later, I did the nail polish remover. So it was separated.
Right there. That's all it says.
I want burger spot.
That's, I go down there on the bottom of you. That's an old one.
2:05. And then at 2:33, I did the other one.
Well, I went by that bottom one.
Separated by a half an hour. Supposed to look at the whole thing.
I do. I look on the bottom.
Yeah,
That's
you
usually
look at
the
you
one-
look at the most recent one.
Right. Why you want
So
burger
what-
before we get
So
to
what
dinner?
what if I had said I'm dying and you need to come home now,
Would you
but
dare be on
then
the
right after and then right after I typed bring me nail polish. You would have brought nail polish home to a dead woman.
Probably so. 'Cause I'm gonna go on the bottom.
Okay. Oh, Marty's on your side. He said, see, learn to text correctly.
Yeah. We keep doing it. You know I don't do that. You should know that by now.
Marty said, then there wouldn't be a second text. He needs to learn how to read texts. Where'd everybody go? So, it's 5:45. Is she gonna let them go home? Everybody left the courtroom. Okay, guys. I guess I'm gonna go eat dinner. I will keep an eye on it, and I will be back if we have a verdict tonight. But I think she's probably gonna let him go home for the weekend, and then we'll be back here Monday, I guess. I usually put it on my, of course not now because I'm on the computer, but in the evening when I'm on a channel, it's on my TV and I use my phone. I just chat on my phone. I can't tag anybody, but not a problem. Okay, guys, I will. No, that was the judge in Tennessee that did Saturday. So, I don't think she's gonna make them come in tomorrow. Tagging is when you put the @ symbol and then somebody's name, but if you're on the computer and you do it, you only have to put like the first couple of letters, and then it gives you a list of people with names that start with those letters, and then you just click on their name. But if you're on the phone, if you're on any mode, it won't let you that type a whole name. And when people have crazy names, it's really hard. So I usually don't even try to type out the whole thing. I use nicknames. You know, like instead of putting Jilly Bean, I would just put Jill or whatever. Yeah, and some of those crazy long names are really, really hard to type out. You know, but like if I was talking to Jilly Bean, I would put Jill, or Marty Duvall, I would just put Marty. Or, you know, Judy, just Judy, or sometimes I would put Judy H without the 79 for whatever reason, because it's just easier that way. Okay, well, dang, I don't know what to do. I guess I'll let you guys go and just keep your notifications on. If there's a verdict, I'll be back. But the way she talked was that she was going to let him go home. Oh yeah, I have some names in my suggestion thing too. Okay, guys.
I should get you some more food.
Who? Oh. Okay, guys. Remember, be kind to people. Oh yeah, I hate underscores. I'm so sleepy. I'm gonna sleep all weekend, y'all. Okay. I don't know what to do. I have a feeling like I'm gonna see you guys in like 15 minutes again, but be kind to people. Who's Cooper? Oh. Bye, Cooper. Wait, what is going on? Did they ask to see evidence or something? Every time I say goodbye, something else happens and I think something's going on. Okay. Bye. Be kind to people, love your family, and Jesus loves you, and so do I. Keep your notifications on the verdict. Bye, guys. Love y'all. Have a great weekend. Bye, Cooper.